morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. Bonus 10 minutes or so, early start. Let's get rolling with Judge Simpson.
Reliance Nash.
Got it. Okay. I have before me a plea form that indicates that the defendant would be pleading to count 2, a joyriding first offense, which is a 90-day offense. On a successful plea to that charge, count 1 would be dismissed. There is also the prosecutor will recommend that the defendant be sentenced as a first offender pursuant to the statute.
That's our full understanding, Your Honor.
That's correct, Your Honor.
All right, very good. Sir, can you please raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall help you God.
Yes, sir.
State your name again for the record, please.
David Reliance Nash.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of joyriding. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand all of that, sir?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, sir.
Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Did he do an advice arrest?
Your Honor, I did submit one to the court that he authorized me to sign with his permission.
Okay, you went through an advice of rights form with your attorney,
Yes.
gave him permission to sign that?
Yes.
All right. Do you have any questions regarding any of those rights?
No, sir.
Under paragraph 5, you understand that those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights that are contained on that form. You understand that, sir?
Yes, sir.
All right. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
May 1st, 2024, at the location of 2771 Plymouth Road, City of Ann Arbor, Washington County, State of Michigan. What did you do involving a vehicle belonging to Lansing Kita that makes you think that you're guilty?
I drove away without her permission.
All right. Much does it. Sir, I do have to advise you that if I accept your plea, and if between the time of your plea and the time of your sentencing you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the defense, Your Honor.
None from the people.
And have I complied with the court rule, and would it be proper to accept this defendant's?
People are satisfied, Your Honor.
And the defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
January 2nd at 8:30.
January 2nd, 2026, 8:30 before Judge Perry. Bond in this matter will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Daniel Cummings.
And the children's attorney on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Cummings, who is approaching.
Your name, sir?
We are requesting an adjournment. We are going to refer Mr. Cummings to a Veterans Treatment Court. He does live out of county, so
Gonna take a minute.
Redford.
Would you be able to get that accomplished by the 30th, or you need more time than that?
Thank you. We can try. See where we can get.
Probable cause conference will be adjourned to December 30th, 2025, 9 a.m. Bond will continue.
Your Honor, Mr. Cummings would like me to address bond.
Briefly,
Your Honor, Mr. Cummings is requesting a personal bond. He is currently in custody with significant medical issues. As you can see, he wears a brace. He has to wear that 24 hours a day. He about a year ago received a back surgery with that involves getting 14 rods in his back. He has to sleep in a certain type of bed, which obviously is not available here in the jail. He also has cystic fibrosis, so he has to wear a vest to shake his lungs. He cannot use that in the jail. He also uses a nebulizer, but he cannot use that in the jail. He's on about 18 different medications, and he cannot receive most of them while in custody. His osteoporosis, he says he receives a shot
every day.
Every day, cannot receive that in the jail. So these things are accumulating. He is relying on one lung to breathe as one of his lungs is collapsed. So he's really struggling.
that doesn't account
medically.
for his fentanyl use, does it?
No, it doesn't, Your Honor, but
I know, and that's the reason that you're in and why I revoked your bond. You
right.
can continue, Ms. Perrini, briefly.
You know, I think Mr. Cummings, this is his first offense, his first time being on bond, his first time ever drug testing, doing anything like this. I think he's really learned potential consequences of his actions. He's been incredibly remorseful to me every time we've spoken, and I think he's incredibly willing to commit to any bond conditions the court may order. He's discussed testing every day and home confinement. He really wants to get home to his wife who has Alzheimer's. He's just really struggling.
May I say something, Judge? Please. I like to address, I want to say thank you for locking me up. It allowed me to get off of drugs, and I feel my mind is clear, my body's clear. I feel fine. I have no urge to, this kind of place is not for me. I've never been, don't have a criminal record. I've never been in jail. Only thing I did, well, you know what I did, and I just need to get home to my wife and my medicines. Otherwise I've had MRSA, I've had pneumonia, but that's what's happening. And I need to lay in a certain bed, an incline bed, or my surgery is not going to hold. I got 13 bars in my back, and I will do anything
I'm
and
sure
everything.
talk to the jail medical personnel, they'll accommodate you in the best way that they possibly can.
They said they can't give me these medicines. Can I be under a house arrest?
Anything else?
You
This isn't a negotiation, but anything else?
mean I have to stay in jail?
Anything else?
I'm not sure what's going on.
I've listened to you. Counsel, I've listened to you.
I'm gonna end up getting sick in here, sir. And can I just be under house arrest? I won't go nowhere.
Sir, we gave you bond conditions. You violated those bond conditions. I revoked your bond because of that. There isn't a medical reason for those drugs that were in your system. You shouldn't have been using them anyway if you suffer from as much as you suffer from at this point in time. And so,
Well, I was addicted, and when they said come in for the Washtenaw corrections, come even if you're dirty, and then we'll help you detox. Okay. All right. Well,
I don't need a response. If people motion for bond reduction is denied, bond will continue as revoked. Thank you. Court does call the case of the people versus Edward Byrne. Come on, people. Where's Miss Cannon? Yes, the AG's here. Miss Cannon is not. And AG, you can put your appearance on.
Christina Beta on behalf of the Attorney General's office, Your Honor.
Good morning.
Good morning.
Where is she?
Your Honor, right here, I'm just trying to get through the door. It was a
You just
juggernaut
needed to
right
use
there.
your elbows. All right.
My apologies, Your Honor.
Sunburn.
Thank you. Your Honor, as it relates to Mr. Burns, Mr. Burns has filed a copious amount of
You wanna
paperwork
state
and we're
your
just
appearance?
asking, yes,
You
Stephanie
wanna
Cannon on
state your-
behalf of Mr. Brandhouse.
And is Mr. Burns here?
Yes, Your Honor.
State your name.
Manuel Barnhouse.
Wait, did you call Brandhouse or Byrne, Your Honor?
I call Burn.
Mr. Byrne, are you present? Mr. Byrne, please be present. Your Honor, Mr. Byrne, we are asking for an adjournment of his case. He is supposed to be appearing by Zoom. He does live in a different state, so I'm just not sure if the time difference has. Can I call him and get him present by Zoom? We spoke
No,
yesterday.
we'll probably wake him. He's out west.
I'm just,
I don't know that.
yes, I'm just asking, Your Honor. He's
No,
supposed
I'm
to
not
appear by.
passing. I got
I understand, Your Honor. Then I would just ask for an adjournment of the matter.
bench warrant will issue for defendant's failure to appear bond. How much is owing in child support at this time? Madam Attorney?
It was around 14,000, I believe, if I'm not mistaken. Is that correct?
I believe so.
15,000 and he posted 27. He posted about a quarter of what was owed at the time.
And he's made several payments since then.
Bond, bench warrant will issue. Bond will be set at $10,000 cash to be applied to the child support case.
Thank you, Your Honor.
Thank you, Your Honor.
That warrant will issue immediately. Thank you.
Good morning once again,
Courthouse.
everybody. Welcome to the Courtroom Files Live. Happy Thursday. We'll continue to ride with Judge Simpson for just a little bit. He's cranky this morning, it seems. But, you know, it's a full house there. That's enough to make him cranky.
State your name.
Kurt James Bushline, sir.
All right, what,
Your Honor, I was speaking with the people this morning, and we are requesting a brief adjournment to see if we can't negotiate out a universal settlement with a matter with Gratiot County as well.
probable cause conference, December 23rd, 2025,
23rd, thank you, Your Honor.
9:00 bond.
Thank you, Your Honor.
Court call case, People versus John Brooks.
Your Honor, Michael Vincent on behalf of Byron Taylor. Excuse me, John Brooks.
Your name, sir?
John Brooks Senior, Your Honor.
All right, go ahead.
Your Honor, Michael Vincent on behalf of John Brooks. He is here on probable cause assault with intent. And he also has third offense drunk driving.
Okay, and you're looking to,
We need an adjournment because we just, literally got retained a couple days ago.
23rd or 30th, which will work. Hello,
I'm helping, Your Honor, sorry. The 30th or just fine.
probable cause conference in these matters will be adjourned December 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Yes, sir. Court does call the case of the People versus Frank Green.
Can you be a wheelchair? Okay, yeah. Good morning, this is Public Defender Warren Kearney on behalf of Mr. Green, who is in custody, Your Honor. He may be in a wheelchair, so they may be slow rolling. Thank you.
Not even responding.
All right.
Is he back there?
A Walker, sorry. Mr. Green, state your name for the record when you.
Frank Henry Green.
Thank you.
Your Honor, we are requesting an adjournment. Mr. Green is in felony drug court in felony court, and we're going to refer him on this case as well, I believe. How are you doing?
Getting signed off to treatment.
Probable cause conference adjourned December 30th, 2025, 9 a.m.
Okay, now
Bond will continue.
go over the.
Thank you. And so that you know, I did approve his release.
Thank you, Your Honor.
To jail. Court does call the case People versus Ron Moore.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Come on up to the podium, sir.
Michael Vincent, on behalf of Ron Moore, state your name.
You're requesting an adjournment for additional discovery.
Yes, I also would like to address a bond condition that I've talked with community corrections with his mom. His uncle is disabled in a wheelchair. We'd like to get the court's permission for him to leave his house, take care of his uncle from 7 a.m. to 7 p.m. I've seen pictures of him. His uncle is in a wheelchair. His mother specifically asked
I'm
me
adjourning
to ask
this
you.
to the 30th. Frankly, I'll let the people respond, but frankly, he's here on a life of capital offense punishable by life. I'm very reluctant to change bond, just give him 12 hours to be out wherever. Frankly, I'm not sure why he's out.
He has a very, very skilled attorney, Your Honor.
Understood.
Good morning.
But not that skilled today. Motion for bond modification is denied.
All right.
Bond will continue. Thank you.
Thanks.
Court does call the case People versus Joseph Griffin. 4 cases.
Trevor Mayville. People.
Good morning.
Good morning, Your Honor. James Fefelski on behalf of Mr. Griffin on the case ending in 1698.
Assistant Public Defender Hannah Appleton on behalf of Mr. Griffin on the remaining 3 files. Mr. Griffin, will you state your name for the record?
Joseph Bertram Griffin, Your Honor.
All right, what are we doing?
Your Honor, it's my understanding Mr. Griffin wishes to waive preliminary examination on all of his files. Can you sign this, please?
Yes, sir.
That is correct, Judge. I did provide the court with the waiver on the 3 files at the PD office.
And I've got mine here.
That one. I don't have the other.
Please sign it. Thank you.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor. Yes, sir.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on all felony counts with the misdemeanor counts following.
Your Honor, we waive formal reading. My client would stand mute at this time.
Your Honor, I'll waive formal reading on my file as well. He'll stand mute on that charge as well.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pre-trial will be set for
January 5th at 1:30 with Judge Hammoud.
January 5th, 2025, 26, 1:30 before Judge Hammoud.
Yes, Your Honor.
Bond will continue.
Thank you very much, Your Honor.
Thank you. Take care of yourself. Court does call the case of the people versus Byron Taylor.
Your Honor, Michael Vincent on behalf of Byron Taylor. State your name.
Byron Taylor. All right, you're requesting an adjournment, requesting.
We've changed our mind. We've adjourned this a number of times. We need to move forward on a prelim exam with the court.
You'd like this set for preliminary examination. It's all discovery then complete.
I have everything that I've been provided.
People have their witnesses available the 23rd.
We'll try, Your Honor.
Probably. Preliminary examination in person will be set December 23rd, 2025, 9 a.m. That is before Judge Barr. Bond continued.
Thank you.
Thank you.
Good morning once again, everybody. Happy Thursday. It's the Courtroom Files. We are live. Got my eyes on 16 different courtrooms at the moment, so decent amount going on this morning. But let's take a little change of pace. We'll go down to Florida. Say good morning to Wade Mercer.
Morning.
Well, we have a warrant out of Liberty County. I took a look at the warrant this morning. I found it in their system, and there's a no bond warrant for violation of state probation. That's what you're accused of. Mr. Walden, you'll be held until you can get back to Liberty County and get this allegation resolved. I don't know when they'll pick you up, Mr. Walden. Usually it's within a couple of days, a couple of working days. But if you still happen to be here in 15 days, I'll ask the jail to put you back on the first appearance list so we can see what's going on. That's very, very rare. Almost never happens. So there's a good chance I won't see you anymore. But if you're still here in 15 days, I will. Any questions?
No, sir.
Have a good day, sir. Keith Custard. Mr. Custard, good morning. Mr. Custard, you're here because you've been accused of violating the terms of your state probation in case 24-601 CF. I've got a copy of the warrant in front of me, and it's a no bond warrant signed by Judge Garcia. So, Mr. Custard, what I'm going to do this morning is I want to get you arraigned because I want to get you a lawyer appointed if that's what you're asking for. Mr. Custard, would you like to have an attorney appointed to represent you in this VOP?
Yes, sir.
I'm going to appoint the public defender's officer to represent you. Listen to Mr. McDaniel, and then I'll see if you have any questions.
Your Honor, we're going to plead not guilty. He has to set this on the January 8th pretrial docket, and I advise him, Mr. Green, and come by and talk to him prior to that hearing.
January 8th. Mr. Mitchell, anything?
No, Your Honor.
Mr. Custard, any questions?
Thank you, Your Honor.
Next case, Eric Orm. Orm. Mr. Orm, good morning. You're here for first appearance accused of one count of petty theft between $100 and $750. Mr. Orm, there is probable cause for this charge. You also have a pending charge that was set to come to court, I believe, in January.
Yes.
So, Mr. Orm, I'm going to appoint the public defender's officer to represent you, and I'm going to ask that you listen to Mr. McDaniel, your attorney.
Thank you, Your Honor.
Yes, sir.
Your Honor, I talked to Mr. Orn, and he's going to plead of no contest to the charge on the case this morning. The state's going to be in agreement to dismiss 25290 MM and also not violate 25594 MRB. Understanding he'll be placed on probation for 1 year, 11 months, 29 days, restitution of $887.77 retail theft class, $370 fine. He has waived his right to a jury trial and call witnesses. He understands he cannot go to any Walmart while he's on probation. And he's been, also understands he's been trespassed at the local Walmart for 2 years.
Thank you. Did he say retail theft school?
Yes.
Okay. Thank you, Mr. McDaniel. Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor, and I guess just clarification, it's 25590 MM instead of 290.
Okay, thank you.
That may have just been a typo that I sent to John, but that's what the case number is.
Mr. Orm, did you
390
hear this agreement? Okay. Thank you, Mr. McDaniel. Mr. Orm, did you hear that agreement?
Yes, sir.
Mr. Orm, do you have any questions about that agreement?
Yes, sir.
And is that the plea that you would like to enter in this case?
Yes, sir.
Mr. Arm, I'm going to accept your plea of no contest to the charge of petty theft. I'm going to find it's freely and voluntarily and with the advice of counsel. I'm going to withhold adjudication of guilt, sentence you to 11 months and 29 days probation, 370 court costs and fines, $887.77 restitution, $3.50 per restitution payments authorized by state statute. Be aware of that. You'll successfully complete a retail theft program. You will have no contact with any Walmart while you're on supervision. And the state is agreeing not to go forward on 2 other cases. Mr. McDaniel put those case numbers on the record. Mr. Orm, it may be possible to get off probation early in your case. In order to do that, you've got to do half the probation, which will be 6 months. You've got to have no violations and otherwise get everything done. So if you do that, you may be able to get off early. The probation office has some other rules, such as being gainfully employed, legally disabled, or full-time student. Mr. Orm, what's going to happen next is they're going to let you use the phone. The reason for that is in case you need to contact friends or family for transportation. Then you will be brought to the courthouse because that's where the probation office is at. When you get to the courthouse, Mr. Goodson will go over the probation order with you, or Mr. Ham, one of the probation officers. Once they go over the probation order with you, they'll give you a chance to ask any questions about it. They'll give you a copy of the rules in writing, and then you'll be free to leave. If you do call friends or family, you can tell them you can be picked up here roughly 30 to 45 minutes at the courthouse. Mr. Arm, do you have any questions?
No, sir. Thank you.
Yes, sir. Wish you the best.
One last thing, Your Honor.
Yes,
He
sir.
was originally scheduled for January 5th arraignment, but we can take him off.
Thank you. Mr. Orm. Mr. Orm. In the case that was dismissed, I saw in the clerk system this morning where that notice was just sent to you 2 days ago. So what I'm telling you is you're probably going to get a notice in the mail. That was the case Mr. McDaniel was able to negotiate a dismissal on. So if you get a notice in the mail for a January court date, that no longer applies because that was resolved as part of your plea this morning. Okay?
Okay. All right. Thank you.
Yes, sir. Thank you, Mr. Mitchell. We have Derek Miller. Mr. Miller, good morning. Mr. Miller, you're here because you've been accused of, good morning. You've been accused of one count of fleeing and eluding with disregard for safety to persons or property. That's a second-degree felony. You've been accused of a driving while license suspended or revoked, third or subsequent. The officer has it marked as a felony, but he doesn't allege the proper basis for a felony. He just puts third or subsequent. So I think that officer's not, it looks like he might not be familiar with that change in law, which was 4 or 5 years ago.
Yeah.
So it looks like there's probable cause for a misdemeanor driving license suspended, but I don't know about a felony. Mr. Mitchell?
Lieutenant Griffith with the Mariana Police Department was trying to call me right before then. He sent me a message saying that he was going to update this affidavit to ensure there's PC for a felony suspended license. So he's going to review it with the officer that wrote this complaint.
Okay. So in order for it to be a felony, your suspension has to be based on certain reasons, and they don't put that in there. They just put it's third or subsequent. Under the old law, that would be sufficient for a felony, but it's not been the law now for at least 3 or 4 years. So anyway, there's no probable cause for a felony. There is probable cause for a misdemeanor driving while license suspended. The last charge is a misdemeanor resisting an officer without violence. So you've got 1 second-degree felony, 2 misdemeanors that I'm finding probable cause for, and I'm going to set you a bond in those cases, but I want to see what Mr. McDaniel and Mr. Mitchell have to add before I do that. Mr. McDaniel, anything on behalf of Mr. Miller?
I don't have anything, Your Honor.
Mr. Mitchell?
Nothing at this time, Your Honor.
Okay, Mr. Miller, I've looked at your criminal history also. I know that you've been to prison, I think, one time, correct?
Yes, sir.
Okay, so based upon the allegations against you, I'm going to set your bond at $15,000 on the second-degree felony, $2,500 on the other 2 cases. Mr. Miller, your total bond becomes $20,000 cash or surety. You have a condition not to drive a motor vehicle, Mr. Miller, because you don't have a license, and because now you've got a fleeing and eluding. So you cannot drive a motor vehicle. If you get caught driving, sir, that would violate the conditions of your bond. Mr. Miller, you'll get used the phone in a few minutes, sir, to try to post that bond. Do you have any questions?
Some of my bond, what, it's 2,000?
If you go through a bondsman, yes, it'd be $2,000. Let me back up. If they charge you 10%, now some bondsmen will negotiate that. Some of them will take 5% up front and they'll work with you on the rest. It just depends on the bondsman and your history. I'm also going to ask the jail to give you your notice for your court date in front of Judge Garcia. That should be January the 6th at 8:30 a.m. Any other questions, Mr. Miller?
No, sir.
Have a good day, sir. So I did a total of 20. Is that right? Mr. McDaniel, that's everything on my first appearance list for the morning. Anything else from the public defender's office?
Short work for Wade Mercer this morning. It's been that way the last couple of days. Crime is on the decline, it would seem, in his area. Good for him. Let's go to... let's do Texas. Judge Stevens. Or not, because the man forgot to unmute. New plan. Let's go back to Judge Simpson, and I'll keep an eye on Judge Stevens. There we go.
I've started to look for it, and we'll meet with him this afternoon.
From the people, all discovery has been sent out, though.
I sent all the paper discovery 10 minutes ago. And I've opened my email and acknowledged that I have received the discovery, Your Honor. I was sent
People
the...
have their witnesses available the 23rd?
That's fine, Your Honor.
Preliminary examination, December 23rd, 2025, noon. That's before me.
Thank you, Your Honor.
Thank you. Bond continued. Court calls case, People versus Tabitha O'Carroll.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Ms. O'Carroll, who appears via Zoom.
O'Carroll, can you unmute and state your name, please? Okay, you can talk, but you need to be unmuted. One with the microphone. You just did it, and there you go. What's your name?
Tabitha O'Carroll, Your Honor.
All right, you're requesting an adjournment on this one?
Yes, Your Honor. If we could just put it over for a week, I believe we're going to have a plea.
That's not going to happen. She's out of custody.
Yes, Your Honor.
December 30th, 2025, 9 a.m.
Yes, Your Honor. Thank you.
Thank you, Your Honor.
Court calls the case of People versus Brian Lasker.
Andrew Childers is on behalf of the people.
On behalf of Mr. Laster, Your Honor. Laster, you need to stand on the side, please. Stand up here.
Excuse me, but, can you let me know what the reasons,
Give me 1 second, Mr. Laster. Your Honor, we are asking for an adjournment in this matter. When I attempted to visit with Mr. Laster yesterday, he informed the Sheriff's Department that I was not his attorney and did not speak with me. I have not had the opportunity to talk to him about his case, but I am your attorney, Mr. Laster.
it was just a, okay.
I promise you.
I love it. Okay, promise you.
I promise I'm your attorney.
December 23rd, 2025, 9 a.m.
Can you let me know what the charge is?
Yes.
If you are mine.
I'm gonna try and get somebody to talk.
Bond will
Yeah.
continue. Thank you.
Can we address the court before I leave here? What the charge is?
Your Honor, my client
I've
wants,
asked around 15 times. So.
what you're charged
Yeah,
with?
I have no paperwork or nothing. What the charges are? If you know, can you just let me know before I enter anything?
Your Honor, my client, he doesn't know what the charges are. And again, I would have gone over this
He
yesterday.
doesn't know what the charges are. Were you paying attention at your arraignment?
It was some, today's 11th. I got recurred back at, for 18th, court date. And then.
Well, let me just go this
told-
way, sir. If you don't understand the charges, you're before the court on a complaint that alleges that on or about September 20th, 2025, location of 410 West Huron Street in the city of Ann Arbor, Washtenaw County, that you did knowingly and intentionally possess less than 25 grams of a mixture containing a controlled substance of cocaine contrary to Michigan statute. Do you understand what you're charged?
Oh, yeah, okay, that was a
Okay,
substance.
no,
Yeah, the sub-
That's a felony punishable by up to 4 years incarceration and $25,000 fine plus court costs. You
Okay, well,
understand
this
the
was
maximum
a
penalty,
substance
sir.
found. Yeah, I was told when I got in
Okay,
the car, it was a substance found.
Mr. Laster, listen,
Substance, ma'am, is that the same?
I need to, yes.
Is that the same?
That's the same thing. Substance, yes.
I had a vial with the.
Okay, don't talk about anything, Mr. Laster, please. I'm going to talk to you. You just have to talk to me and I'll explain everything, okay?
I never had that.
I understand.
Control.
I understand. You have to go back, but I will talk.
Fine, we'll continue.
Okay.
Thank you. Court does call the case of the people versus Jaleesa Robinson.
Good morning, Your Honor. J. Grant Miller, G58658 on behalf of Jaleesa Robinson, who should be on Zoom. We have been texting since about 7:02 a.m. And unfortunately, I believe I forgot.
Jaleesa Robinson. Right here.
Your Honor, I cannot locate my phone. I don't know if I left it at the office this morning, so I have no way to contact her directly, and I apologize to this court.
Bench warrant will issue for defendant's failure to appear, bond $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
Court calls the case of the people versus Charles Hudson.
He's in the back.
Christopher Coyle, P 49708, appearing on behalf of Charles Hudson, who's approaching the podium. Mr. Hudson, when you get to the podium, can you state your name for the record, please?
Charles Hudson. Charles.
Louder. Got it. I got it.
Okay, thanks.
Go ahead.
Judge, we're going to set it for a preliminary examination this morning.
All discoveries complete.
Yes.
People have their witnesses available the 23rd.
Can we set it for the following Tuesday, the 30th?
I certainly can. Will that work?
Works for me as well. Thank you.
Preliminary examination in person will be set for December 30th, 2025. 9 a.m. or 12.
Judge Washington.
9 a.m. before Judge Washington.
Thank you, Your Honor.
Bond continued.
All right, let's go back to Judge Stevens. He finally figured out where his mute button was and pressed it.
Kristen. Hello. This is an announcement. What are we going to do, Colleen?
Judge, Mr. Keller is requesting 4 weeks reset. He's still working through discovery, and now that some more is on the case, I think that he's hoping to have conversations with her about. So if he could just have a reset.
All right. Yeah, this is over a year old.
I understand, Judge.
I know, but when's something going to get done? Because I'm looking at the phone. Delay. It's just been kind of something that this court just gets antsy over. Get that. Look. Ten settings. What are we gonna do?
Unfortunately, Judge, I don't have a good answer in terms of timeline.
Oh, that's a good sign. It went in the trash. You know, 10 settings is, we can't open the door for that. That's far too. Yeah, y'all had to have made a decision by now. Come on, I'll make the decision for you. Move over time. Darren Peace. 24 CR 1632. Darren Peace. And this one.
Mr. Kelly is requesting another 4 weeks on this case as well. He's still been Mr. Wood in terms of movement is the knowledge that I have.
Okay, this one's kind of old. It's over a year old. Well, we'll state, what do y'all say? There aren't as many resettings in this one.
Well, it's actually older than the other case, Judge.
I'm not sure how long Mr. Kelly has been. Again, Judge, I apologize. My knowledge is limited. I'm just here to come with him today.
Okay. I'm resetting this for 2 weeks. Okay. So Mr. Kelly can be here and talk to me.
Okay, Judge. Thank you.
Oh, thanks. Mr. Macon, Charles Amber.
Yeah, our Daniel is the prosecutor on this case, and I had a few questions asked him. I'd ask for 2 weeks till he's back, and I can finalize everything. It'll be
2 weeks reset.
This one's much younger.
Maynard Sorto.
You should have sent a plea on to that, Judge. I think it's ready, should have.
What are you doing, Jasmine Young?
I've been speaking to Mr. Boyd about
Jasmine Young, someone, yeah, what are we doing?
Mr. Boyd and I have been speaking about the
Is that
possibilities
okay?
of dismissal. I don't know what that was.
You guys. Reset 2 weeks on, Jasmine Young. Maynard.
Final resetting, and then I need to swear in just a sort of.
He's done with. Meanwhile, John, rest. Hey, Matt, Brent on Carlina Solomon.
We're working on that one. We're in ask for.
Come on up, then.
Raise your right hand, swear or affirm to have approved all three of the amendment of proof of you.
On this one,
You have your right thumbprint,
any criminal history on this?
place it
I
right.
didn't see it in the indictment, but.
Let's see.
Same one, place it right there. Okay, you can stand in front of judge.
You did? That's something I'm up here.
We're just.
I'm sorry.
Just grab this.
Don't say anything initially, Judge.
You don't have any criminal history? What are you
You're
asking?
Miss Young?
Yeah. Oh, on this one?
TCF. I'm sure that has everything to do with the nature of this offense, Sean.
Who is the victim? What's the relationship?
It's a person in Prince Hall. I don't think
They don't know. Yeah, no,
I think it was
related.
just, I don't think they're related at all.
And the victim is still vehement about moving forward.
This is not my case, this is Mr. Boyd, so I don't have that intimate knowledge.
Mr. Boyd was here, what would he say?
He would say dismiss it.
No, he absolutely would not.
All right, you said you want to.
We're working on it still, but that.
But
do the
if he
eighth.
understand that she can't get in, I don't think she's eligible for probation in front of a jury with, I'm sorry, you interrupted me, because it's aggravated assault, a deadly weapon is used. You can't get probation when a deadly weapon is by a jury.
We're still working on a judgment since Mr. Boyd's not here and we're currently in.
You didn't know that, I bet.
Yeah, I told her that I should get off of probation.
That, no, that you can't receive probation from a jury. The only option they have is punishment for prison. But you can get probation on an agreement. But to a plea agreement. But a jury, I can give you probation, but a jury cannot. 3 weeks to think about this and talk about it. It's fine. 3 weeks, we get a recess. Here's the final and.
You want to handle Sorto, Judge?
I'm gonna go to Sorto. 25 CR9,
Change.
80 Maynard, Sorto. Present. Ms. McNally is here representing you. And does the defendant waive a formal reading of the indictment? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about May 21st, 2025 in Jefferson County, Texas, you committed a third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with? This is a third-degree felony, sir. This means that if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached, you would be pleading guilty, placed on deferred or unadjudicated probation. That can be up to 10 years in length. Fine $500. There would be terms and conditions of probation normal and customary for this type of offense. Is that your understanding of the agreement? If I follow this, you have no right of appeal. Do you understand? You have soft voice. She's going to take everything you said. How do you plead to this, guilty or not guilty? Yes. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? Yes. Show you what marked as State's Exhibit 1. Did you sign this document voluntarily? Understand it, discuss it with your attorney. Are the contents true and correct? Yes, sir. State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freedom and voluntarily, man. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All proof, so help you God.
So yes.
Yes, sir. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
I'm going to follow this agreement. I'm going to find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. Even though there's sufficient evidence supporting a guilty plea from State's Exhibit 1 admitted to find you guilty of this felony offense. Instead, I'm going to follow this agreement and defer or postpone any finding of guilt so long as you follow these terms and conditions of probation. And you will be assessed a fine of $500. Other terms and conditions of probation, which are normal and customary, is the length of time is up to 10 years.
We're requesting 5, Judge.
What?
He has no criminal history.
Any objection?
No, Judge.
Done.
Correct.
5 years. And do well, a third, 1 2/3. And then you're a free bird. Okay. The probation office will prepare the documents, either sign, you will sign, and you will begin probation. Good.
He's good to see probation, Judge.
Yeah, see probation.
Thank you.
You want to throw somebody in jail? That's good.
I thought a little bit.
You tricked the square.
I'll have Judge. Excuse. Thank you.
Whatever happened to John West?
All right, let's change things up again. Let's head to Lake County, Ohio. We'll say good morning to Judge Collada, see what's going on with him.
We are here in case 25 CR 1422, State of Ohio versus Richard D. Williams II. Present in court is the defendant, who's accompanied by his attorney, Mr. John Fatika. We are here today for a change of plea hearing. It is the state's understanding that the defendant is prepared to withdraw his previously entered pleas of not guilty and enter a plea of guilty to count 1, tampering with evidence, a felony of the 3rd degree with the attached forfeiture specification, and count 4, possession of cocaine, a felony of the 5th degree. And the state would dismiss the remaining counts at the time of sentencing. There is no agreement with regard to sentencing. Thank you.
Thank you. Mr. Fatika, does that sound right?
Yes, Your Honor.
And Mr. Williams, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor.
Excuse me. They indicated to the court they believe it's your desire to withdraw your previously entered pleas of not guilty and plead guilty to 2 of the 4 counts in this indictment. It's a 4-count indictment, right?
Correct, Your Honor.
The other counts would get dismissed. We would then defer sentencing or continue that to a future day to get some evaluations completed. Come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe is the fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, all the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything that I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right, give me 1 second, please. All right, let's get started. How old are you, sir?
39 years old, sir.
Are you able to read and write the English language?
Yes, Your Honor.
Any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Prior to coming into court here this morning, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No, Your Honor.
Now, did you receive, well, I know you did, a copy of the indictment. Looks like you got it sometime around middle of October. It's the document that sets forth the charges. You got that?
Yes, Your Honor.
I know that was the new indictment. There was a previous indictment, but this was the new one. And you've had a chance to look that over?
Yes, Your Honor.
Now, in that indictment, you're charged with 4 counts. You're pleading guilty to 2 of those, so I'm going to go over those 2 charges with you. In count 1, what is alleged here and what you're admitting to is on or about May 7th, 2025 in Lake County, Ohio, that you, knowing an official proceeding or investigation was in progress, was about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with purpose to impair its value or availability as evidence in that proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, there's also a forfeiture specification attached to this charge, and what it alleges that you had or possessed an interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself. Whereas an instrumentality is some type of property that there may not be anything illegal about it in and of itself, but it's being used illegally or to facilitate a crime, and you can't possess or to use it for that purpose. And here it's alleged there's heroin, cocaine, and a pipe. The whole purpose of this is that you forfeit any ownership interest you have in any of that property. It doesn't increase any potential penalty you face. It just allows the state to be able to destroy that property at the end of the case. Any questions about that?
No, Your Honor.
Now, the second count you're pleading guilty to is count 4. What's alleged here and what you're admitting to is on or about May 7th, 2025 in Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
This charge also carries with it that same forfeiture specification. You understand that?
Yeah, I'm not getting it back, I know. Yes, Your Honor.
Now, there are 2 other counts in the indictment, counts 2 and 3. Those are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Any questions about either of those charges?
No, Your Honor.
Well, then, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision as to each count. That means all 12 jurors would have to agree one way or the other, whether you're guilty or not guilty as to each charge, before they can return a verdict of either guilty or not guilty as to each charge. You understand that?
Yes, Your Honor.
You understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty or presumed innocent of these charges. And that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden we have in our justice system. And what it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would be bringing witnesses to come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. She could ask him anything she wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request this court issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if there was anyone out there that was unwilling to do that voluntarily or on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and put you up in the stand and make you answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if I accept your guilty plea, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all then about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No questions.
Do you understand them all?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the state. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 3rd degree in count 1. This offense is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either, what would be 12, 18, 24, or 30. So if I impose the prison term in this count, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve for count 1. Do you understand that?
Yes, Your Honor.
Now, count 4 is a felony of 5th degree. It's punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, since there's 2 separate charges here, if I were to impose a prison term, I'd impose that on each count. Then as a judge, I do have the discretion to run those prison terms either concurrent or consecutive. Concurrent means together at the same time. Consecutive means one after the other. You serve a prison term on the first count, finish that, then the prison term on the next count. Do you understand the difference there?
Yes, Your Honor.
So in this case, if I impose the maximum sentence on each count and ran the terms consecutive to each other, you're looking at a maximum possible prison term of 4 years in prison. Do you understand that?
Yes, Your Honor.
Now, do you have any other charges pending against you right now anywhere?
No, Your Honor.
I understand if you still are, but you were on post-release control when this happened?
Yes, Your Honor.
You still on post-release control?
Yeah.
How much
Should
more
be
time?
getting off soon.
How much more time?
October would be the end of post release.
October of 26?
Yeah.
So less than 12 months?
Yeah.
I do need to advise you that if you're on post-release control and you commit a new felony, the judge who is sentencing you on the new felony, which is me in this case, does have the authority, I'm not required to, and it's not mandatory, but I do have the discretion to terminate your period of post-release control and impose an additional prison term of either 12 months or the amount of time you have left, whichever is more. So it sounds like if it's less than 12 months, I can impose a prison term of up to 12 months and terminate your PRC. If I did that, it would have to be served consecutive to any other prison sentence I imposed for the underlying charges. Do you understand that?
Yes, Your Honor.
What are you on PRC for?
When I was here in 2018,
Okay.
the trafficking.
Okay. Now, if a prison sentence is imposed in this case, upon your release from prison, you could be placed on post-release control for this case. It's not mandatory with these charges. It's up to the parole authority to decide that. If you were, it could be up to 2 years. If you are on post-release control at any point for this case, you never violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there are other sanctions that could be imposed. I could fine you for these charges. On the tampering charge in count 1, you could be fined up to $10,000. On the drug charge in count 4, you could be fined $2,500. Altogether, that's a $12,500 possible fine. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
You could also suspend your driver's license for the drug charge in count 4 for up to 5 years. Do you understand that?
Yes, Your Honor.
And as I indicated before, and you acknowledge any interest you have in that property that's in the forfeiture specifications will be forfeited. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I did explain the possible prison sentence you face. I used the word possible when I did that because prison's not mandatory with these charges. With these charges, you are eligible for probation or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't automatically mean you'll be put on probation? It means I'll consider that, if that's what you're asking for. I'll look at all the information presented to the court. Then I'll make the decision I think is the right thing to do. You understand that?
Yes, Your Honor.
Now, if you are put on community control, it could be up to 5 years of supervision. And as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months, the condition of your probation. You understand that?
Yes, Your Honor.
Further, if you are on probation at any point here and you violate any of the conditions of your probation or community control, we would have a hearing to see if you're a probation violator. If it was determined that you were, I could extend your probation up to 5 years, if it wasn't initially 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison at that point. If I did it then, again, it could be for the period of time that I explained earlier, up to a maximum of 4 years in prison. And that also could be consecutive to any other prison sentence you may be serving at that time for something else, or that you're being sentenced to on a new charge at that time. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for the sentencing, you'll have the right at that time to say anything you want. Anything you want me to know or you want me to consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
Give me 1 second. All right, well, do you have any questions at all about these possible penalties that you face by pleading guilty here?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about these cases, this case with your lawyers? I know Mr. Watson's been your attorney throughout, but you had enough time to talk with him, go over everything with him, him answer your questions?
Yes, Your Honor.
Same with Mr. Fatika today?
Yep.
You satisfied with the advice and counsel of your lawyers?
Yes, Your Honor.
Have they or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the guilty plea freely and voluntarily?
Yes, Your Honor.
All right, then, do you have any questions for me at this time regarding anything we've talked about, the rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
You need more time to speak to your lawyer before we go forward with your actual plea of guilty?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial if we did have a trial. I want you to listen to her because then I have some follow-up questions for you, all right?
Yes, Your Honor.
Similar.
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on May 7th, 2025, in Paynesville Township, Lake County, Ohio, Lake County Sheriff's Office conducted a traffic stop on a vehicle being driven by the defendant. The defendant consented to a search of his vehicle. Inside the vehicle was a clear plastic bag on the driver's side floor near the center console that contained 2 syringes, a blue medical tourniquet, a cotton swab, and a pop cap. On the way to the Lake County Jail, the defendant advised a deputy that he had a crack pipe that had been shoved in his waistband and had fallen on the floor. Deputies did locate that pipe from the floorboard in the cruiser. Furthermore, while being booked into the Lake County Jail, the defendant dropped something in front of the scanner platform as he was going through the body scanner. He attempted to run back and grab it. It was a bindle that was located, as well as another second paper bindle located on the defendant's person. All of the suspected narcotics were sent to the Lake County Crime Lab for testing, and it was confirmed to contain cocaine, a Schedule II controlled substance, in an amount less than bulk. For purposes of the forfeiture specification, the heroin was also confirmed. Thank you, Your Honor.
Thank you. Mr. Williams, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we did have a trial?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as she presented them? Are those facts true? Did you do what she said?
Yes, Your Honor. I was trying to get rid of it before I came into the jail, and I forgot about the little piece of crack that was in my waistband. But as he brought me back, I was like, man, I'm going down high, and I wasn't trying to conceal nothing. Like, I just went over there and tried to eat it and get high, you know, like, I'm a drug addict. And that was it, you know, I just got bum rushed and threw it on the ground for him, you know.
Well, you're pleading guilty to tampering with evidence.
Yeah.
Tampering with evidence means that you attempted to hinder an investigation that was going on or was about to go on by doing something with the evidence.
Yeah.
What you're telling me is you didn't do that.
I did do that, but it was in my head thinking it was a different reason. It was.
Well, but that's the problem. When you commit a criminal act, it's not just the act itself; it's the criminal intent. What was your intention at the time? So your criminal actions may have satisfied the portion of the charge here for that, but you have to have the state has to prove that you did this for the purpose of impairing the value of that evidence in an investigation or proceeding. They're trying to destroy it or hide it or whatever, so that it wasn't available to be used for a further investigation. And you're saying you didn't do that. So at a trial, the state has to prove that you swallowed that cocaine for the purpose of impairing its value or availability as evidence at the trial.
I didn't even think about that. I was just thinking, I'm trying to get high if I'm going to jail.
Then you're saying you're not guilty of this charge. I mean, you're here to plead guilty to the charge. You're saying...
But theoretically, I'm guilty of the action, just not the intent.
Well, a crime constitutes action and intent. If you don't have both, you don't have a crime. The state has to prove both. They have to prove the action, and they have to prove the requisite intent. And if they can't do that, then you're not guilty of this charge. So I don't know if you want to talk with your lawyer here for a moment, but what you're admitting to, you're not admitting to committing the offense. So I'll give you a moment to talk. Let me put this.
Okie dokie. They do that whole static thing there when they mute. Let me see if I can bump it forward a little bit. We're a couple of minutes on the way back machine. Let's see here.
Signed it here in court. Now, my understanding is before I walked out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Fatika, is that accurate? Did you review this with Mr. Williams, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of the document to you?
He did, Your Honor.
Is that correct, Mr. Williams?
Yes, Your Honor.
So you understand what it says?
Yes, yes, Your
Do you have
Honor.
any questions for me about it?
No, I understand it, Your Honor.
It also appears you signed the document. Did you sign it?
Yes, Your Honor.
Mr. Fatika, you witnessed that?
Yes, Your Honor.
Ms. Himmeline, you as well?
I did, Your Honor.
All right, let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. Further, the court finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, tampering with evidence, a felony in the 3rd degree in violation of 2921.12a, as well as count 4, charging with possession of cocaine, a felony of the 5th degree in violation of 292511 of the revised code of forfeiture specification. Counts 2 and 3 will get dismissed at sentencing. Sentencing, however, will be deferred. I'm going to order a pre-sentence report and investigation, drug and alcohol evaluation. As far as bond goes, this bond initially was posted, I don't know, I think 25,000, 10%. Then that case got nollied and that was released reimbursed, and bond was set at an owner cognizance. I'm not sure why it was done like that. This isn't your case, is it?
It is not, Your Honor.
Well, I'll continue the bond at owner cognizance. That's what the bond is in this case. I'm not sure why it just wasn't transferred over, but yeah. So bond will be continued at owner cognizance. So what that means, Mr. Williams, your bond is nothing more you need to do about it. It's been posted. Your signature was your bond. When you are released on an owner cognizance bond, you have to appear at all future court dates. If you fail to appear at a court date when you're on an OR bond, that's a separate felony that you can be prosecuted for. It's a felony of 4th degree, so you can get up to 18 months in prison in addition to whatever happens on these other charges. So it's obviously important you show up at all future court dates. Now your next court date is January 26th at 2:45. That's your sentencing.
Okay.
So that's what you need to be here for. Prior to that, though, you're going to have to go to the probation department to meet with them, because I've ordered these reports, and the only way those reports get completed is if they conduct some interviews with you. So it's important you show up there on time when scheduled. It's important that you're open and honest with them, because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they'll let me know, and I would certainly consider that, obviously, at sentencing.
Yeah, yes, Your Honor.
One of the conditions of your bond also is that you don't use any drugs while you're on bond. You have to submit urine screens. If they should come back positive, your bond will be revoked and a warrant will be issued. You understand that?
Yes, Your Honor.
So you're going to leave here now. You're going to go to the probation department, fill out some initial paperwork, and get your dates to come back for the interview. So make sure you go there immediately after here. Bailiff will give you some paperwork to take with you, and you're going to go there right from here. All right?
Yes, Your Honor.
All right. Ms. Middleton, anything else for the record?
No, Your Honor.
Mr. Katika.
No, thank you, Your Honor.
Thank you.
Okay, friends, we're going to change it up and do something a little bit different from what we normally do on this channel. I'm going to take us to Tennessee and Judge Wolf, and we're going to listen to the sentencing for Sarah Jo Fuson. This is actually a trial that I've been working on a video for in the background, so someday you'll be able to see the whole thing. But long story short, she was found guilty of child abuse. Now, good news straight away, this child is alive. It is okay. You know, there wasn't like life-altering injuries, but she worked in a daycare, and the parents found bruises on the child. But it's interesting because she is actually the daughter of the sheriff of Montgomery County, Tennessee, and they actually had to move this case over into Judge Wolf's court to avoid any conflicts of interest. So I'm guessing this is probably going to be about an hour proceeding, so it's not going to be a short one, but these things are always good in Judge Wolf's court because he spends a lot of time working through things, and it's good legal process to watch. And it's also an interesting case because just kind of the nature of it, because it's a daycare worker, wasn't necessarily the best trained person in the world, all of that, but she finds herself in trouble. So we're going to go there, and let's see how that goes.
All right, we have one case on the docket today, State versus Sarah Jo Fuson. Stay ready. All right, let's bring up Ms. Fuson. I failed to ask, is the defense ready as well? All right. Then we are ready to proceed with the sentencing hearing. The state may call your first witness. Make sure that microphone. All right.
Yes, Your Honor, the state would offer the pre-sentence investigation report completed by Ms. Wendy James as an exhibit to this hearing.
All right. Any objection to you? All right. If you will turn on that microphone there at the table, whatever, that'll help us to make sure we're on the record. So.
I'm David Rabin, co-counsel. Introduce myself. We're just going to reserve objections to the end of the hearing.
Any objection until the report is reserved, so we'll mark that report as Exhibit 1. It is in the...
We'd ask that Your Honor incorporate the proof from the trial into this hearing today. And we would call Miss Macy Hyde.
Right. Yeah, I pulled some of those things out, so that you'll come right up here, please, ma'am. Yeah, that'd be great.
Good morning, ma'am.
Good morning.
Could you please state and spell your name?
Macy Hyde, Macyhyde.
And you're the mother of Olivia. And have you prepared a victim impact statement today that you'd like to read?
Yes, sir.
With your court's permission, I would ask her to read.
All right.
Your Honor, my name is Macy Hyde, and I am the mother of Olivia, the child who has been deeply harmed in this case. There are no words to describe what it feels like to realize your baby has been harmed by the very person you trusted to care for her. When I first saw the bruises on Olivia's little arms, I felt a mix of confusion, fear, and indescribable pain. I had trusted Sarah with the most precious thing in my life, my daughter, and that trust was shattered. I am here today to share the profound and lasting impact the defendant's actions have had on my daughter, on our family, and on me as her mother. Since the abuse, our lives have been consumed by emotional turmoil, fear, and uncertainty. Olivia, though too young to fully understand what has happened, continues to suffer the effects. For months after the incident, she woke up screaming in the night. She had panic attacks and was showing an overwhelming fear of sleep. Putting her down at naps and bedtime became an emotionally charged ordeal. Even a year after the abuse, she still exhibited signs of trauma. We had to seek play therapy because she refused to let us touch the backs of her arms. And she displayed concerning behaviors during play, acting out as a student or a teacher, which hinted at her distress. A simple touch in the wrong place could trigger a meltdown, with Olivia begging us not to touch her that way, as if she was reliving the horrors. As a mother, the emotional turmoil has been unbearable. Every day, I live with the constant anxiety that my children may be hurt again, fear that grips me every time I drop them off at school or leave them with anybody other than myself. Things that once felt routine, like school drop-offs, babysitters, and play dates, are now moments of intense dread and second-guessing. I regret deeply that I took Olivia back to Sarah the day after the abuse. The guilt that haunts me for that decision weighs heavily on my heart, and I still to this day struggle to forgive myself. After watching the trial videos, my husband and I experienced nightmares, uncontrollable tears, and unable to shake the images from our minds. We both sought therapy to cope with the trauma, including EMDR, to help erase the haunting memories. Rewatching the footage in October just reopened old wounds, bringing back intense pain in the memories of that time. Our daily life has been irrevocably changed. My children have become more cautious, and I have become hypervigilant. Every change in behavior raises a red flag in my mind. The fear I now carry is not a life that I ever imagined for my children. Yet it is our new reality. This summer, I struggled to send our son to daycare after we moved. The anxiety becomes so overwhelming for me that I almost pulled him out after just 3 days of being there, fearing the worst from what had happened to Olivia. Thankfully, Olivia is now in a school environment with teachers whom I trust, but the fear remains. I still scrutinize every detail of her day. I overanalyze every situation, and I am constantly on alert for any signs of distress, whether it's just a bruise or a change in behavior. The trust we once had in the world around us is shattered. Sending my children to school or leaving them in the care of others now feels like a risk that I cannot fully bear. The ripple effects of this trauma has permeated every part of our lives. I am deeply concerned about the long-term emotional scars that she may carry. I wonder how this experience will shape her sense of safety, her relationships, and her future. No parent should have to question whether their child will carry lasting pain from something that they never should have had to endure. I also understand that the fear and the anxiety that I live with will not disappear overnight. This trauma has fundamentally altered me, both as a mother and as an individual, and I am no longer the person I was before the abuse. I am forever changed. Your Honor, I ask the court to remember that behind this case is a real child, a baby who was frightened, abused, and betrayed. I ask the court to fully understand the deep, lasting harm that this has caused to Olivia and our family. She deserved to feel safe. She deserved to be protected. Instead, she was harmed in a way that no child should ever be harmed. The consequences of this abuse will affect us for far longer than this legal process. I thank you for allowing me the opportunity to share the impact this trauma has had on our lives, and I hope the court's decision reflects the gravity of the suffering and the fear that my family continues to endure. Thank you.
Thank you. We'll mark that as an exhibit next in order, which would be 2.
Your Honor, other than that, the state would ask to rely on the written memorandum that was submitted, and we would reserve argument for the end.
All right.
That's the state's proof today.
Does the defense wish to offer proof? All right. All right.
Good morning, Mrs. Fuson.
Good morning.
State your name for the court, please.
My name's Jennifer Fuson.
And you are the mother of Sarah Fuson, is that right?
I'm Sarah's mom, yes.
And where do you live?
I live in Woodlawn, Tennessee. I've lived there my entire life.
And how are you employed?
I'm a school teacher, elementary school teacher.
How long have you been a school teacher?
And this is year 28.
Describe your relationship with your daughter, Sarah.
When Sarah was born, she was the biggest gift in our life. We just enjoyed, she was the sweetest child. She gained the nickname Sweet Sarah. Everything about raising her was a joy to me. She was actively involved in so many activities and so many things. We were actively involved in our church. And one of the greatest blessings was she was baptized at age 7. And that gives me lots of comfort.
If you would describe for the judge the impact that this prosecution and trial has had on Sarah.
The impact it has had on Sarah is great. From the beginning, there was an immense amount of media and social media coverage because of who her father is. This caused extreme embarrassment and shame. I knew that that day, January the 10th, when I came home from work and heard what Sarah's account, that very confident, independent girl that we knew and raised was gone. As time went on, she felt that life had no meaning and like she had a gorilla on her back. She attempted suicide. We committed her to a mental hospital for a couple of weeks. She came home on lots of mind-altering medications. The medications would change off and on. In the process, she's gained about 50 pounds. When we got her kind of back a little bit mentally stable. Trying to get a new job was very embarrassing, to say the least. She would attempt one after another. With the charges on her record, it would come back when they did a background check. So she would get fired. And some of those firings were very, very humiliating. During this period, I made sure Sarah was with me or someone at all times. I did not feel safe leaving her by herself. Everything is worrisome and extremely painful. Finally, she landed a job. She made friends and she started thriving, but we knew this trial was looming over us. And we were not going to get through this unscathed. Her anxiety was eating her up. The girl that you saw in court during the trial was ridden with anxiety and was not the same girl that I raised. It's the amount of pain all of this has caused has been a very heavy burden to live with and to carry, and we will continue to live with and carry this.
Is there anything that you would like to say to the Hyde family?
Yes, I would. I've wanted to speak with them from the very, very beginning. I am so sorry for all of your pain and all of the trauma and all of the mistrust in society that this has caused you. I've tried. I wanted to from the very beginning to reach out. I was advised not to. I even wrote you all a letter. And I know it wasn't given to you. We do not, as a family, condone what Sarah did that day. We don't, but we do love our daughter. And just as you see, anything your children do in life, you try your best to raise them and support them and get them through the hard things in life. I do know that Sarah did not go to work on January the 9th, 2023, thinking she was going to harm a child. Also know that Sarah did not think her actions at the time were hurtful. It was only when she saw herself on video that she thought, yeah, that was rough. Sarah was raised in a home of public servants. She only wanted to serve others. She reverted that day back to the daycare training at nap time. She should have never, ever, and no one should ever work in a daycare where you are enclosed in a room with lots of children by yourself. Daycare system needs a big overhaul. Lots of training, lots of supervision. And there should always be more than one adult in a class, regardless of the number of children in that room. Regardless of everything that you guys have been through and what we have been through, Sarah is not a throwaway person. She is kind, she is generous, she is loving. As her family, we need her, we depend on her, and we will have a big hole at our table and in our hearts until she is returned home to us.
Thank you. Those are my questions.
Thank you, ma'am. You may step down. Defense have any other proof? All right, an allocution statement will be allowed, so she'll need to come to the podium. or actually come to the witness stand. So. You don't have to be sworn. This is an unsworn allocution, which you're allowed to make a statement without having to be placed under oath. So.
Good morning. Go forward with your statement.
I want to start by apologizing to Ms. James, the probation officer, about my comments about the case. I was still adjusting to jail and was going through a difficult time. That's not how I feel about the case. I never intended to hurt Olivia. I had been working at Tylertown for 6 months when this happened. I loved my job, I loved the children, and I got along very well with the staff. I used to look forward to going to work every day, to be with those children and be in the environment. I was always alone with 6 children in my classroom. Sometimes it was difficult to give one child the attention they needed when I had 5 others to care for. I find myself hurrying and multitasking all the time. It was also hard to give the new children the attention they needed to transition into the toddler room. I didn't realize I was being rough with Olivia in the moment. I recognize that I was rough with her and regret my conduct. To Olivia and her parents, I am so very sorry that this happened and what this has put your family through and the trauma that Olivia had to go through. If I could go back and make this right, I would have been calm and gentle as usually I was and not rough. I love children and animals, and it is not in my nature to be rough. I hope someday that Olivia and her family can forgive me and we can move past this. I want to thank my parents and my family for supporting me and standing by me through this very difficult process.
Thank you.
Thank you, ma'am. You may step down.
We do not have any additional.
State have any rebuttal proof they wish to offer? All right, I'll hear you in argument. You wish to make any argument?
Just as it relates to enhancement factor 4 that the state included in its memorandum, see the response from Ms. Fuson that we received yesterday. We think the language in the Adams court is clear. The court states that the vulnerability enhancement relates more to the natural, physical, and mental limitations of the victim than merely to the victim's age. And the state submits that in this case, we're dealing with a 13-month-old victim that did not have the ability to resist in any way. She didn't have the ability to tell someone and ask for help, nor did she have the ability to testify as to what occurred at a later date, which is what the language that is cited in the Walton case as well, that the state included in its memorandum. As far as enhancement factor 14, we think the language in that is clear. It says position of trust or a professional license. We submit that Ms. Fuson was in a position of trust, no greater trust than caring for that of someone else's children. We submit that enhancement factor 14 does apply in this case. And the same with enhancement factor 15. We think the wording of that is clear as well. States that this occurred on the grounds of a pre-kindergarten through grade 12 while children were present. The proof showed that this occurred on the grounds of a pre-kindergarten while children were present. It doesn't mention anything about it has to be an attack on the school itself. It just says while they're present. That's what occurred in this case. We think all 3 enhancement factors apply, and we'd ask that Your Honor include those in your consideration. Thank you.
Raymond?
Good morning, Your Honor.
Good morning.
Be a little longer. Sentencing spread for Class A felony. I know there's another count, but we're here to talk about the Class A felony. That's, the sentencing spread is 15 to 25 years. Under recent amendments to the law that apply in this case, it is a 100%. There's no parole. There are no credits. Served every day. My position is pretty simple. The government's pleadings say they want a sentence more than 15 years. They haven't said what number they want, but they want it more. I think that a sentence of more than 15 years is brutal, unnecessary, and consistent with the sentencing law. I want to think about 15 years for a minute. I think everybody on this side of the table went to college, most of us. That's 4 years. 15-year sentence is 4 times of being in college. When you put it in real terms of spending time, it's forever. The college was an education, and for most of it, it was having a good time. Being in prison for 15 years is being locked up in a cage. I was at the penitentiary at the women's prison 4 days ago, parole hearing. There's barbed wire everywhere, silent as a tomb. You don't throw sentences around like candy anymore. There's no such thing as a mid-range sentence to make everybody happy at one end or happy at the other end. We are talking about real years here. State sentencing memorandum focuses on the aggravating factors, which I'll address in a moment. But there are other important parts to the sentencing statute. It's no secret that I served on the Sentencing Commission and was vice chair of the Sentencing Commission for years. The Sentencing Commission was necessary because our statutes were in horrible disarray. Sentences were completely out of whack, and we wanted to bring some order to things. So let's talk about the vulnerability of the victim. It is an element of the crime. The element of the crime was enacted as Haley's Law back in 2025 when they enhanced it by children under 8 who suffer severe abuse. That's the point of it. To say that this child was severely injured or whatever is an element of the crime. There's no other way to talk about it because they had to prove severe injury. They had to prove that the child was under 8. This is the same exact thing. And if it does apply, it is so close to an element of defense, it runs the risk of double counting. So I suggest that factor's off the table. Now, the next factor is that this happened in a place where there's children. It duplicates the position of trust factor. She had to be there if she's in a position of trust to be a daycare operator. She had to be there for this thing to have even occurred. That particular enhancement factor is designed specifically, we read it with common sense, of people that go to schools and have school shootings and harm the school as an entity. That's the whole point of it. It's an absolutely appropriate enhancement factor. Totally, because if some person shows up at a school and starts shooting the place up or committing violence in a school where there's kids and stuff, of course that needs to apply. That's not what happened here. The aggravating factor needs to be read with a dose of common sense. That's the whole point of it. That's why it's there, and it duplicates the position of trust factor. So I suggest that's off the table. It's just not applicable here. And if it is, it's de minimis because it's not what it's designed for. And then we talk about the position of trust. She was not licensed. She was in a position of care of these children. and yes. So I suggest that that enhancement factor may apply to some degree because she had care of the children. I was not unmoved by the mother's testimony at what happened to her child, that she put her child in the care of the daycare and my client. So is there a position of trust there? To some degree, there is. I don't want to be disingenuous and say that it's an irrelevancy. Of course it is. But I suggest that it duplicates the other factors to where they don't apply, so we're just dealing with the one situation. But think about this offense could not have occurred unless she was in that particular position. So it's duplicative. Now, let's talk about the mitigation, which we have to consider, because you consider the aggravating factors and the mitigating factors. The mitigating factors are abundant. My client, I don't think had ever been arrested in her life. No prior record at all. This event occurred on one occasion, and not like the many child abuse cases that Your Honor sees where it goes on for weeks and months and years. It's an isolated event. So those are mitigating factors there. The fact that she tried to commit suicide, the fact that she was despondent over what she had done is huge mitigation in the case and detracts from whatever abuse there exists. And so I suggest that when you consider all this mitigation involved in the case, that 15 years is the appropriate sentence. Now, there are other factors that the court would want to consider. When the statutes were enacted, they were 30%, 35% for range one offenders, which she is. The sentencing grid was designed for parole. That's the way it was. So when you have a sentence of Class A of 15 to 25 years and there's a 30% parole, the courts would consider parole as part of it. Even if you gave the minimum of 15, then the person would be eligible after 5. Now the sentences are at 100%. The sentencing mindset that we had 5 years ago is inapplicable today. Our sentences have gotten inflated, but there's no change in the sentencing lengths. It doesn't work the other way, unfortunately, when the sentences are at 100%. So we don't have to talk about the fantasy that we engaged in where you say, well, you give somebody 9 years and maybe they'll be out in 3 and maybe they won't. So maybe we can adjust the sentence accordingly. This is real time. It's just like the federal government. When Mr. Strines and I go to federal court, it's 100% over there too. But the federal government had some common sense, if you can believe that. They reduced the sentence lengths to account for doing away with parole. And we engaged in utter madness in our state, where we left the grids the way they were and went up there. This is not the time or place for me to complain about that. We'll pay the price for that one day. And there'll have to be another sentencing commission to undo all this mischief. But the problem is, Your Honor is imposing a sentence today that's 100%. That will not change. We incarcerate more women in this country than any other country in the world, with the exception of some Middle Eastern countries would actually kill women. The purposes of the sentencing and the guidelines must be considered. Your Honor knows that. The court's going to articulate that. Let's talk about that. The sentence says under 102 must be imposed that is justly deserved in relationship to the seriousness of the offense. Justly deserved. Why in the world does this girl need more than 15 years at 100%? The law also requires elimination of unjustified. Punishment must consider restraining defendants with a lengthy history of criminal conduct. That we're not have that here. Ms. Fuson does not have any prior history. Next, the court has to consider whether other measures less restrictive than confinement have been applied unsuccessfully. She'd been on probation 5 times, violated them. Of course the court would consider that. So we've tried everything we can. Your Honor does that every day. That's not what we have here. Most importantly, the sentencing principle says the sentence imposed should be no greater than that deserved for the offense committed. That's the so-called parsimony provision, the least possible sanction. No greater than that deserved. We have to balance everything. Why in the world should this woman deserve more than 15 years in hard labor in prison? In 15 years, Your Honor, nobody's going to care or know.
Are we now having inmates perform hard labor like chain gangs in the prison system?
No, they
that I'm
don't,
unaware
but that's
of?
what the statute seemed they get. The statute said you got to give them a Bible, that they're supposed, they have these archaic.
I just didn't know when you mentioned 15 years at hard labor that was actually an accurate representation of our prison system.
No, not any, well.
I understand it's an eloquent reference to other images that we create by putting people in prison, but go ahead, I'm sorry.
Your Honor, I don't want to go too far afield, but I have had constant calls of prisoners being subject to abuse and killed in prison.
I understand that prison is not a pleasant experience.
It's without using profanity in the court, it's heck on earth. It's a terrible place. It may not be hard labor per se, but it's a hard life. People are extorted like crazy over there. Anyway, but I mean, the original statute says you got to give them a Bible and you're supposed to do all that, but it's not a good place. It's a terrible place. So I suggest the least severe measure is 15 years. Now, I want to talk about the offense a little bit. I wasn't here for the trial. The offense is aggravated child abuse. It's the one offense that's required to commit knowingly. Now, knowingly, we know what knowingly means for murder. We know what knowingly means for most offenses. I mean, you have to intend the result. Child abuse can be committed effectively in a reckless mens rea because it's objective and subjective. You're aware that you're hurting the child, or you should be. That's the definition of knowingly. We have a separate definition of knowingly for child abuse. So if she said, I did not knowingly intend to harm this child, that's true, but she did nevertheless. But she was acting in a reckless way because the statute said should have known. And should she have known that she was harming this child? I suppose so. But I suggest this is much different than the child abuse cases that Your Honor sees, where the child is being shaken all right to the point of death. And they know what's happening, and they intend to harm the child that she didn't intend to harm. I suggest that should be weighed in the balance as well. It doesn't diminish the pain that the parents feel, but it's not the intentional crime. Now, let's talk about 4035-210. It says that the minimum sentence within the range of punishment is the sentence that should be imposed because the General Assembly set the minimum sentence for each felony class to reflect the relative seriousness of each criminal offense of classification. That's what it says. The minimum sentence should be. Is child abuse, aggravated child abuse, serious? Absolutely. But the statute puts it 15 years for that because it's serious. But that's what the statute says. And then you weigh the aggravating and mitigating factors. But I suggest that this is not that complicated. That's what the statute says. It's the minimum sentence. That's what the legislature said. Then you have to consider how long a defendant's going to serve before becoming eligible for release. 4035 says the court must place on the record the estimated number of years and months the defendant will serve before becoming eligible for parole. It's the truth in sentencing. So when you impose the sentence, you say, well, everybody, we think she'll be eligible for parole after 30% or 40%. You have to consider that and tell everyone. 100%. The court should consider that as well. And then you have to consider the evidence on the pre-sentence report and the strong R. What is a strong R? It is a risk assessment. This risk assessment is low. That is a factor the court's required to consider by, is she a threat? No, she'll never work in a daycare center ever again in her life. She'll never be near children in the rest of her life. Impossible. Her risk is low. Is that a mitigating factor? Of course. If it was high, the state would be up here saying and waving it around. They're not. This is not an issue of how tough we can be or what it looks like or making one side happy. Let's look at the person as an individual and ask what is deserved. Locking this woman up in a cage for more than 15 years, I suggest, the state suggests, their position is unconscionable, inconsistent with notions of mercy. And please do not think that the government will come back up here and say, well, what's another daycare worker going to say? Well, I can abuse this child all I want because I'll just get the minimum sentence of 15 years at 100%. That's not, they're not going to say that. The deterrent effect of imposing sentences diminishes to insignificance after 5 years. Any sentence of more than 5 years, except for maybe for murder, the deterrent effect doesn't have any more effect than that. The numbers become unreasonable, have no added deterrent effect. So why say 16, 17, 20 years that we're going to deter this sort of behavior? 15 years will deter any human. For all those reasons, I'd ask, this person here is a human being. These laws were designed to reflect a sentence for her. The indictment is the state of Tennessee versus her. And the court is the arbiter of what that sentence should be. That's why we have judges. Sentencing guidelines are advisory, but at the end of the day, it's a very human experience. 15 years at 100%. I never thought I would stand in a courtroom in this state and say this such a thing. That's where we are today. No sentence more than 15 years is deserved and would be inconsistent with the rest of the guidelines. And I thank you, Your Honor.
Holder, Mr. Moore.
With all due respect to counsel, I've been around for a long time, and I've heard this before, and perhaps it should be addressed to the legislature, but that's not where we are here today. Your Honor, presided over this trial, you've heard all of the evidence, read the pre-sentence report, considered the statements and testimony here today, and on behalf of the state of Tennessee, I would submit that, yes, at this point in our history, the legislature, for some crimes, has decided that, yes, a person must do real time for a real crime. And this was a real crime whose effects will last far beyond 15 to 25 years. The state submits that the enhancement factors that we argued, that General Holder argued, are present. Case law, yes, it's under 8, it's not double counting, because a 6-year-old or a 7-year-old could come in and testify about what happened to them. That's the entire reasoning for the State v. Adams and the cases that follow, and that's been for 20, 30 years, at least. Happened on a pre-K, there's no dispute about that. Not that, oh, this enhancement factor applies if it is on the grounds of a pre-K and committed by someone who has a firearm or someone who is shooting or killing. No, no. Legislature could have done that, and they may well do that. They've added enhancement considerations before, but that's not what this one says. And obviously this was conceded where Ms. Fuson, that child was placed into her care, custody, and trust. She betrayed that trust, as we have seen time and time again. The arguments for sympathy and mercy in this case, I submit, are not and should not be well taken because of the facts of this real crime. State certainly submits that whatever sentence Your Honor imposes will be based upon the law and the evidence, consideration of all the factors. But on behalf of the state of Tennessee, Olivia Hyde, family of the state does sincerely believe this should be more than the minimum sentence. Thank you.
Well, any court that has to impose a sentence in a case like this is required to follow, as has been pointed out by both sides, the considerations and the guidelines that our state legislature has put in place to govern the sentencing in criminal cases. Those sentencing considerations are set forth in Tennessee Code Annotated 4035-103, and that provision states the following: to implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. Or measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Obviously, this, as has been pointed out, is a case that requires whatever sentence I impose, the minimum sentence is 15 years, and the service is 100%, meaning she's not eligible for parole at any point in time. So some of those considerations are not really relevant. Obviously, the only one this court would be inclined to consider of those factors would be that, it is in this court's opinion important not to depreciate the seriousness of the offense of aggravated assault against a minor child of 13 months. But the rest of those factors don't really apply in this case. The sentence imposed should be no greater than that deserved for the offense committed. Mr. Rabin makes an eloquent argument about the fact that our state legislature and the sentencing guidelines are that the minimum sentence is the sentence that should be imposed unless there's some basis for not doing so. But that's why we consider the aggravating and mitigating factors to help determine whether the minimum sentence is the applicable sentence. Inequalities in sentences that are unrelated to a purpose of the chapter should be avoided. The sentence the sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. It goes on to talk about the potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative or length of the term to be imposed. So those are just some of the factors that I'm required to consider. The first thing I'm required to do then after that is to consider the range of the defendant as a criminal offender. And there's no dispute about the fact that she is a range 1 offender, which means that the range of sentence for count 1, which she was convicted of aggravated child abuse, is 15 to 25 years. And that range of sentence for count 2, which is child abuse, and that is a range of 2 to 4 years because it's a Class D felony. Then the court has to look at the mitigating and enhancing factors in order to determine whether or not the minimum sentence should apply or whether or not a greater sentence should be imposed. Before we do that, it's important to remember, and I know Mr. Rabin was not here for the trial, but this court has observed this trial from the very beginning and listened to the testimony, listened to all of the medical proof that was provided. I have reviewed that video, watched the video that was provided at court, and I think the jury did too. And I think the jury not only watched it, but they watched it very intently because they, during deliberations, came back and asked to see another portion of that video that more or less highlighted the area that of concern regarding the injury to the child's head. And as a result of that, the jury found that the defendant had committed the offense of aggravated child abuse. The factors are, of course, not the factors, but the evidence also substantiates that she had abused the child by the bruises on the child's arms, which is what the triggering effect or the first notice to the mother in this case was that there were bruises on her child's arms, and Ms. Hyde then inquired us and brought that to the attention of the daycare, and the daycare pulled the videos to start looking, and they themselves alerted law enforcement. In other words, so it's important to note that not only did the mother have concerns, but the daycare operator, the management of the daycare, thought there was great enough concern after watching the video that they alerted law enforcement. So we can minimize some of the factors that we want to, but there's no question that there was evidence that this trial, that this child was harmed. I know the defendant has argued from the beginning that she didn't really hurt this child in a severe way, and has argued that through medical testimony of her own expert witnesses that the child was not actually suffering an injury to her skull, and that there was no skull fracture that occurred. But Dr. Lakin was the testimony of the state's witness, and she testified that there was both a concussion and a probable fracture of the skull, and that it did amount to severe child abuse. And the jury considered all of that testimony of all of the expert witnesses, and they found that, in fact, the defendant had committed the aggravated child abuse. Now, looking then to the aggravated and mitigating factors that I'm required to consider, state argues in their sentencing memorandum that the first consideration is the victim of the offense was particularly vulnerable because of age or mental disability. And as the defense points out, it is the statute we're dealing with that she was convicted of does make it a much more severe crime when it is a child below the age of 8 years. And as a result of that, the age of the child is a factor that's part of an element, if you want to call it that, of the crime for which she was convicted. I understand the state's argument that there is a basis for considering that no matter when the child is particularly unable to resist the crime, summon help, or testify at a later date. But I have to agree with Mr. Raven that I think this statute, the way it's worded currently, would exclude considering that one in a case where the child is 13 months old, and as a result of that, I do not find that victim of the offense particularly vulnerable because of age or mental disability is a factor I can consider. Clearly it is the fact, but it's not a factor that I consider as an enhancement factor when the statute has been amended to make the crime of abusing a child under the age of 8 years to be a minimum Class A felony with a minimum sentence of 15 years at 100%. So I am, out of an abundance of caution, ruling that number 4 does not apply. Number 14, that the state says the defendant abused a position of public trust or private trust, or used a professional license in a manner that significantly facilitated the commission or fulfillment of the offense. That statute does not require that the defendant have a particular license, nor that she be some professional individual that, in my opinion, at least, we have found people who were guilty, and that was an enhancement provision when they were just some family member that provided care, but they violated a position of trust. In this course of finding, there is no greater position of trust that we can put a person in than to provide care for a minor child. You know, we have a society that people have to work. It's a a family that has a 2-income household almost to make ends meet. So they have minor children, they've got to have a way to provide care for those children. And when that is the case, they place those children in the care of some agency or some individual. And when you drop your child off to a child care person, there is no greater trust that you place in an individual in any way than the trust that you place in that person that they will not only provide care for the child, but that they will not harm the child. It's one thing to negligently allow a child to be injured. It's quite another when the provider of care is the person who actually causes the injury to the child. So I do find that this is a position of trust and that factor would factor in as an enhancement provision. I think the defense's argument that she was only in a position of authority is not relevant, nor do I think that the fact that she didn't have a license and that she was monitored really applies, because that monitoring didn't prevent her from causing the injury to this child. They had the monitoring, they had the video, and she still caused the injury. The last one is that the defendant committed the offense on the grounds of the facilities of pre-kindergarten through 12 public or private institution of learning where minors are present. I understand Mr. Rabin's argument, and Mr. Rabin obviously had some involvement in some of the sentencing as a participant. But the way the statute is reading right now, it doesn't distinguish. The legislature could have distinguished it and said this is only applicable to those instances where people commit violence against schools and so forth. But it is not worded that way, and so the way it is worded fits this case. The offense was committed on the grounds of the facilities of a pre-kindergarten, and that's where we are. So based on those factors, I find that both of those factors are applicable in the case. The defense has filed mitigating factors, and they argue that Sarah Jo Fuson's youthfulness at the time of the offense is a factor that the court should be considering. That actually is, I think it is number 6, the defendant, because of youth or old age, lacks substantial judgment in committing the offense. And I think it's important to read that language of that mitigating factor, because this is not a situation. She was a younger person, but she was 22 years of age, and she had attended college, had an associate's degree, if I recall correctly, already at that point, had worked in daycare operations in the past. So this is not a situation where she was barely 18 years of age and with no life experiences. So I do not find that is a factor that would apply because of her age, that she lacks substantial judgment in committing the offense. She should have known better based on her experience, if nothing else. The second is that they've cited is she lacked a sustained intent to violate the law. And that one is basically that the offense was committed, let me find the language, that she committed the offense under such unusual circumstances that it indicated there was no sustained intent to, here it is, number 11, the defendant, although guilty of a crime, committed the offense under such unusual circumstances that it is unlikely that a sustained intent to violate the law motivated the criminal conduct. There is some argument to be made that this is an isolated event, but when you review that video, this child came into this room the very first time, and that was her very first day there. When you review the video, when they set this 13-month-old infant at a table, Ms. Fuson does, and then she goes over and sits and starts stroking her hair and looking at her phone. As the child starts to be unsteady at the table, she goes over, grabs her up, sits her down and forcefully in the chair, which is, in this court's opinion, and I think the jury agrees, where the bruises to this child's arms likely occurred when she grabbed her by the arms and set her down. She then went on, and the video goes on to nap time, and the nap time portion of the video shows that she put the child on a cot, and the cot had a hard plastic headpiece, and then it had a screen or a net type surface that was the sleeping area. Olivia, as a 13-month-old often do, raised up while Ms. Fuson was trying to get other cots out and trying to get other children. ready for nap time, she went back and she pushed her down and covered her up. And that repeated itself on the 8th time that she pushed this child down. And that as she did so more forcefully with each of those situations. With the 8th time that she did it with such force that, in this court's opinion, and I think the jury agreed, it struck this child's head against a hard plastic surface, and the child remained motionless. Now, I've seen the letters that the family and friends have submitted, and where they make the argument this child wasn't harmed and the child moved in some way. But Dr. Lakin observed that video, observed the child's behavior and Ms. Fuson's behavior. And at that point in time, Dr. Lakin said this child was unconscious. Now, people who are unconscious may twitch or do something like that, but they don't. You don't see a 13-month-old who is raising up, active, and then suddenly stops and is completely motionless for 35 minutes only because she was forced to the bound, at least not in this court's experience. And so as a result of that, it is my opinion that there was a sustained intent to abuse this child, as demonstrated from the behavior of starting with slamming the child down at the table, putting bruises on the child's arm, and then 8 times that she forced this child's head down on that. So I do not find that that factor is a mitigating factor as well. The third one is the kind of catch-all, which is the work ethic and family contribution. And there's no question, and the family has supported Ms. Fuson. They have been here for her during the trial. They have repeatedly supported her and shown, that support. And in the letters that they have submitted, and I've read them all, those letters are basically talking about what a good person she is and how she's cared for other children and she's done things for the family. Unfortunately, some of those also mimic the defendant's own position about the fact that this child wasn't really harmed and how unfair this process was and so forth. But I think that there is proof that would sustain that as a mitigating factor. So I do find that factor would be applicable in this case. So it boils down to the court to make a decision regarding the sentence. This court observed this trial. I observed the defendant's behavior during the course of the trial and her testimony from the stand during the trial. I'm not sure that I have, before today, I didn't see any indication that Ms. Fuson accepted any responsibility for this. In fact, to the contrary, she not only didn't accept responsibility for her actions, she minimized those actions. She gave excuses for those actions. She talked about how badly she was being mistreated and how unfair things were. I think it's instructive, even though this has been made an exhibit, that when the pre-sentence report was prepared, it's an opportunity for a defendant to give their version of the events. And when our probation officer went to, Ms. James went and talked to her and took her pre-sentence report and gave her an opportunity to be heard, here's what she said. It was O's first day in my classroom, and I was having issues with her sitting up in her chair at breakfast time. So I quickly yanked her back in her chair to keep her from falling to the floor. The second video is of nap time, and I was trying to get her to lay down. She wouldn't, so you can see me laying her down several times, and some parts did look rough. They say I caused bruises, but also say I caused a head fracture. I made sure she did not hit her head, and it was medically proven that she didn't have a skull fracture. But here I am in jail for it when it's not what that was. It was a wormian bone. Then during the interview on November the 13th of 2025, the defendant reported that she was not frustrated during the incident and was only trying to keep the child from falling out of her chair during feeding and trying to get the child to take a nap during nap time. On multiple occasions, the defendant made the statement, and I'm going to quote it exactly as it's written. I shouldn't effing be here. I didn't do anything. She also stated she had talked to friends and plenty of them say they have handled their own kids that way. She stated that the victim's mother is a liar. and that the child was fine the next day and that she brought her to the daycare and handed her to the defendant. She reported they lied in court and the child had no fracture on her skull. She stated the bruising on the child's arm just looked like a rash, and that the defendant's family is, quote, pissed because she shouldn't be there and she didn't do anything. She reported she wasn't allowed visits at the jail and that her family needs to sue the jail so she can get out of there. She also discussed how the food sucked and she really wanted a Dr. Pepper. The interview became solely focused on how this incident has affected the defendant with no concern for the child. That is the pre-sentence version of the events that Ms. Fuson gave. Now today, we saw a different side of her, and obviously if anyone who has a good lawyer is going to tell the defendant that you've got to come forward and make an allocation where you show remorse, I just don't find in this court's opinion that her expressions of remorse today are particularly sincere. I think they're motivated by good advice of counsel, as well as the fact that she realizes, having said those things, that those things can come back to bite her. Based upon all of the factors that the court has considered, my observations of the trial, the demeanor of the defendant, both at trial and during her testimony, her statements in the pre-sentence report, and all of the other factors in this court, I'm of the opinion that as to count one of this indictment, the defendant should be sentenced to 20 years in the Tennessee Department of Corrections. In count two, I find that she should be sentenced to 4 years in the Tennessee Department of Corrections, and those sentences will run concurrently with one another. And that is the judgment of the court. As to the motion for new trial, I know that there's already been a motion for new trial that has been submitted. However, the court is of the opinion that the state needs an opportunity to respond to that motion or to prepare for that motion. I'm here in January, and we can set it for argument on January the
I could be heard on issues regarding.
all right. You want to be heard on the motion for new trial?
Well, this is a skeleton motion.
I understand. And
And
I'm not holding you to it. I
Right.
understand you have the right to amend it.
Right, but what I wanted to do is I wanted to deal with several things, and I was wondering if my client could be brought back in here.
Yeah, let's bring Officer Howell, if you'll bring her back in, so she needs to be here for this argument. You had filed, Mr. Raven, we could recover this or cover this again whenever she comes out. You had filed a motion for her to be declared indigent for purposes of preparation of a transcript, and I have signed that order. I don't know if it's been, I've already signed the order, and I'll hand it to the clerk to mark that file.
Your Honor, please, for the record. My client returned to the courtroom. This is
I don't have any problem finding that she is indigent because of the sentence that she's been imposed.
Yes, Your Honor. All right. Next, as I do in these cases, the record reflects that I was just retained to do the appeal. What I do routinely in these kinds of cases is I file a skeleton motion for a new trial because the court's imposed sentence to 30 days is running right now. So to stop the 30 days from running, I file this skeleton motion for a new trial with leave to amend. There's no way that I'm going to intend to argue the motion for a new trial until such time as I get the transcript. I've also filed a motion, which the court has granted, for her to be declared indigent, but also for the court to direct that the transcript be prepared at expense, which I believe Your Honor has already signed. For me to do the real motion for new trial, obviously I have to have the whole transcript. I don't think state's opposed to that, and they do that routinely. That's going to take several months. There are some evidentiary issues in here that I've got to look at. So what I'm asking the court to do, the client's in custody, is simply reset the motion for new trial with leave to amend for June or July. Let me get this transcript typed up, prepare whatever I need to prepare.
I don't have
here.
a problem with doing that for you, Mr. Raven. I think that's good lawyering on your part. My only concern is that I have just had to deal with a motion for new trial, the same event. We tried the case in 2022. The defense lawyer filed a motion for new trial, but then requested to amend that motion for new trial upon the receipt of the transcript. 3 years later, he argued the motion for new trial. Even though I was the trial judge, my memory is not bad, but it's not good enough for me to remember every single detail of a trial 3 years ago. So I'm glad to reset this unless the state has some opposition. We can set it, I think I'm here in June, May. We can set it for May, at least for a status, to see whether or not you've been able to get that transcript. And if you're ready, if not, then we'll find another date.
That's fine.
I just
Your
don't
Honor.
want it to be years down the road. So.
Your Honor, I do not do that.
Now, the difference in that was I think the defendant got probation in that case, so they were in no hurry.
Well, given the fact that my client is incarcerated, I want to move this thing as fast as I can. So I have no intent of.
Well, let's set
delaying
it,
that.
your motion for new trial for status on the 13th of May, May 13th, if that's the date that's available for you. And as I say, if you're having trouble, and our court reporter has many cases, we've tried about 7 or 8 cases in the last few months. So, it may be difficult for her to get it expeditiously get a copy of the transcript ready for you instantaneously. So we'll see where we are in May.
And just for the record, what I normally do in these things, just leave it for status. Once I get the transcript, obviously I have to read it, absorb it, and come up with the issues. And then we'll just leave it there. And then if I need additional time, I'll advise the court. And we can just,
Well, as I say, let's look at it in May. Let us know if you need additional time.
That's
and we'll
fair.
certainly give you that opportunity.
That's fine. Judge, that's fine. Your Honor, I'm going to have to turn on my phone to make sure I'm available that day.
That's fine.
If you could just give me one moment.
We have other dates in May. We can set it if we need to. So. We also have May 20th if the 13th is not available.
Also, I'd ask, Your Honor, when the court adjourns, if my client could be put in the back, Mr. Striens and I need to confer with her.
That's fine. There's a room that we can allow that to take
Thank
place.
you. Is that okay?
All right. Anything else?
Let me just check my date. What date was that, Judge?
May 13th or May 20th?
May 20. Let's do that.
May 20th?
Yes, Your Honor.
More, Mr. Holder?
And that'll be for status, and I'll report in no matter where I'm
All right.
Thank you.
Thank you. All right. This court stands adjourned.
Okie dokie, folks. Had some good lawyering there, whether or not you agree or disagreed. I think he fought hard for his client. Was justice done? Yeah, I think so. 20 years, I put in the poll, would he go high or low end? Turned out he went right down the middle. But I think that was worth watching, so I hope you, I don't know if enjoyed it is the right word, but you know what I mean. Special greeting to those of you watching over on Kick. I see you over there. Feel free to say hi in the chat. This is day number 5 for us on Kick, and it gets a little better every day. More and more people watching, so it's great to be over there and great to have you guys watching. Let's go to Texas, 9 to 11% more Judge Boyd, as is our commitment. Of course, she's muted. What is it with judges muting today? Let's bump it a little forward.
That's a third-degree felony.
There we go.
Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, if for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Counsel, do you believe he has a rational as well as a factual understanding of the charges against him?
He must.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both.
Ms. Elatorre, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
Yes.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived in jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 2, waiving count 1. There's a $1,000 fine. State recommends deferred adjudication. They were taken in consideration 2025 PF 07403. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Judge, but I forgot to go back to the prosecutor. She in 5 years. The agreement was for 5 years.
No, you can't agree to the length.
Oh, okay. I thought we had I thought it was in the file.
Yes.
Oh, okay. Very good.
So did you understand that to be the plea?
That's our agreement, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State Dr. States Exhibit 1 knowledge documents.
I've reviewed those documents with my client. We have no objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
All right, I'm gonna need you to speak up.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. State defense. I endeavor to stay in my lane, but this is a possession 1 to 4 grams. And the weight of the drug, according to the lab report, is 1 gram plus or minus 0.02 grams. So if y'all still want to go forward with this defense, I will, but the range of punishment, I'm sorry, the offense is possession of a controlled substance, penalty group 1 gram to 4 grams. They did the weight of the drug, and when they did the weight of the drug, it's 1 gram plus or minus 0.02 grams.
I noticed that as well, Judge, and I discussed that with my client. Considering what the original offense was, we thought that was a good middle ground.
Okay, I mean, if this is what you all want to do. All right, thank you. All right, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Nothing other than, as the court can see, this is his first offense, hopefully his last offense. He has no priors other than a couple of pending cases rising out of the same offense. A date in.
What are the pending cases
this
arising out of
court.
this offense?
I think it's a UCW and a reckless driving.
And he doesn't have any other criminal history?
That's me.
If no other criminal history, the defense counsel said the reckless driving did step to this, that was taken into consideration, and then the ECW is gonna do files in rent.
I just want to know. All right. Court is going to sentence you to 2 years deferred adjudication. There's regular reporting by Zoom or in person, regular random UAs. Are you currently employed?
Yes,
Doing what?
I work at AutoZone as a commercial driver, Your Honor.
Okay. Proof of employment within 30 days, no employment as a home health care provider or with minors. Do you have any children?
Your Honor.
All right, there's to be a TAP evaluation out of custody, follow recommendations. Do you live with anyone who has children?
No, I live with my grandmother, Your Honor.
Okay. No residing in households with minors?
No, no.
Oh, that's what I'm ordering. But thank you for letting me know. There's to be 120 hours of community service restitution. What's your dream job? Are you doing your dream job or?
My dream job is, I'm not currently doing my dream job. My dream job is what I'd like to say. I wanted to apply to be an electrician. I already had my my electrical apprentice license. I just need to go and like do like hours. So I've worked under like master electrician for a couple hours, but I need to reapply for my electrician license.
All right, there'll be 120 hours of community service restitution. If you obtain your trade school certification or whatever certification you need, be it to be an electrician or a welder or whatever it may be, the community service hours will be deemed satisfied. Otherwise, you're going to have to do the community service hours. There's going to be field visits 1 time per month for 3 months. Probation, is there anything else? Anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand, Your Honor.
All right, we've got the record in this court to be successful. Communication is key. Do not disappear on probation. If there's an issue, let probation know about it. If you feel they're not addressing it, you can always come back and address it with me. You understand? Now, as a side note, here's my question. The piercings on the cheek, does that hurt?
No, Your Honor. I mean, it's a pinch.
Oh, and do they go underneath the skin? I always wonder if you want it yourself, are you able to do that or no?
This one specifically, it doesn't need a doctor to put in, so, I can remove it by taking off the top, and it's a bar under my skin.
Oh, do you just unscrew it or?
Yeah.
Okay, I always have these questions. All right. Good luck to you. Just, probation will go over conditions with you, then you'll be excused.
Thank you, Your Honor.
You're welcome.
The more you know with Judge Boyd. Okie dokie, let's go to Louisiana. Give them a try this morning.
And the time is 9:11 a.m. My name is Danny Barra, serving as your chairman today. To my left this night is Mr. Ledoux. Our panel is at DOC headquarters in Baton Rouge, Louisiana. With the staff here, please introduce yourself for the record. Taylor Cavalier. Today, our remote location is Hunt Correctional Center. With the staff at Hunt, please introduce themselves for the record.
Assistant Warden Jason Russ.
Christy LeBlanc, classification. Ashley Bradley, classification.
Joe Butcher's classification.
Thank y'all. And we have a Mr. McClinton here. Would you give us your full name and DOC number for the record?
Larry Joseph McClinton, 315102.
All right, I'm going to give you a brief explanation of the process. We're going to give you a chance to speak and tell us what you did to cause yourself to be incarcerated and why you should be released. We're going to have the warden give us some input about your behavior there. We're going to allow public comments from 3 supporters and also 3 in opposition. We're going to have the district attorney give us a statement, and we'll conduct an interview, and then your attorney or you will speak last. So today we have for parole consideration Larry McClinton, DOC number 315102, who is a multiple first offender who was convicted of first-degree murder, attempted first-degree murder, and manslaughter on August 13th, 92 and January 27th, 94, and sentenced to serve life in prison and 30 years plus 30 years in Rapides and Grant parishes. You have a parole eligibility date of September 3rd, 2018, a good time date, not eligible because of the crime, and your full term date is life. Does that sound correct, Mr. McClinton?
Yes, sir, it does.
Right. So give us your explanation of the story, what you did to get yourself in jail and what you did to get yourself to a position where you think we should release you early.
First, good morning, sir. I appreciate you guys for giving me another opportunity to better myself, to come before this board for release. Sir, you stated it correctly. I'm here before you for killing 2 people and injuring another person. So first, I would like to say to the families of the victims, I apologize. This is my 3rd trip on the board, but it doesn't make it any easier to revisit that part of my life. So I really want them to know that I apologize. You know, we can't reach out to them. So in 1992, in April, in August, I was convicted for first-degree murder. In that particular case, I went with a friend to a woman's house. We usually get her to purchase alcohol or whatever for us. And he got into an argument with her. He ended up leaving out. I continued the argument. I had a 25 automatic pistol, and I brandished the weapon. And not only did I brandish the weapon, sir, but I fired it. The result was the death of Angela Harding. At the same time, they had a partition, a separation in there, and her mother was coming in. And I was startled, and I fired again. This time, the bullet entered around the jaw area, exiting around the neck, and she was injured. But not only physically injured, you know, she had lost her daughter, and I was the cause of that, sir. I was still in high school at the time. You know, the crime wasn't discovered. No one knew it was me. And I tried to escape from it. After high school, I went to the Marine Corps, and I went through a few psychological evaluations. Just still running away. I admitted to a supervisory officer I was taken off Fleet Marine Force, put into the reserves. I came back, but there was nothing actually done. So in '92, I'm going to a party. Basically, I resorted back to the same thing. I went to a party. There was a dispute about which way we were going. And I had become accustomed now, just like in the first one, to have this was another small caliber pistol. It was a 22. And, you know, brandishing it, you know, made me feel like I was just invincible. You have to do what I say do. And the result of that argument was I fired to the side and entered into the neck area and exited out the head area, and it caused death. Completely responsible. I apologize. It's again, I'm before you for that. You asked, why should I be released?
Yeah.
Sir, I know I can never bring back the crimes that was committed. The only thing that I can actually do is take the opportunity to not only better myself, but better those around me. I run into a lot of people in my same predicament, a lot of guys in my same condition. It's a mind state. It's trying to get away. It's trying to put yourself in a position where you don't have to be accountable, where you don't have to be responsible. But in this world that I'm trying to get back to, that's what's required. What I built myself around during the 33 years that I've been incarcerated, sir, is education. I've been a lead tutor at 3 institutions that the state have, helping guys attain their high set. I've also dug deep into my religious faith. Here at Hunt's, I'm presently the prayer leader. We call that an imam in the Islamic community. So I lead our Friday afternoon prayers, and I lead all our educational classes, our Talim classes. And I'm also the assistant coordinator for the transition program, sir. And our transition program deals with cognitive behavior therapy, as well as RDAP, our residential drug abuse program. And I actually live in the dorm with the participants that we help. And I see myself in a lot of the guys that, you know, try to get over, guys that try to justify, guys that try to blame, or guys that's, you know, try to use denial as a key. And I utilize my own experiences to try to help these guys to give them a better understanding of exactly what we're doing. My parents used to always tell me, I see what you're doing. And I always thought that they couldn't possibly know what I'm doing. And I see that in the same guys, the participants that I deal with, you know, just thinking that so I always use myself as an example. So I want to bring this here to society. I've been working with a lot of transition facilities, a lot of people out there that's formerly incarcerated, that's out there doing great things. A lot of opportunities have opened up for guys that's been formerly incarcerated, and I want to get out there and help with that push, sir.
Thank you. Thank you for your input.
Thank you, sir.
Do you have anything you can tell us about his behavior and his violations?
Yes, sir. He hasn't had a disciplinary report since 2020. He does reside in our transition program as a mentor. He's a minimal level trustee here at Hunt. He has completed our anger management courses, substance abuse courses, although he doesn't get the CTRP credits due to the nature of his crimes. So he's done, you know, basically everything that we've asked him to do here at Hunt. He does have a low title risk score. And he has several certificates in his packet that y'all should have copies of from his educational achievements.
Thank you very much for that input. We also have in support several people. We have, I'm gonna start out with the people who are not gonna speak. I'm gonna list them first. Joe and Kara Zander, they're friends and in support on Zoom, not speaking. We have Monica Sylvester, a friend who's in support, not speaking on Zoom. Barbara Holland, an aunt who's in support, not speaking on Zoom. Mo Moore, a friend who's in support on Zoom, not speaking. Zabedi Appas, a friend who's in support on Zoom, not speaking. Nathan Spears, stepfather, who's in support, not speaking, and at Hunt Correctional Center. And we have Miss Betty Spears, your mother, who's in support at Hunt and speaking. And we'll go ahead and start with Miss Betty first.
You can stay seated. They can hear you.
Good morning to everyone. My name is Betty Spears, and I am Larry McClinton's mother, Mom, as he calls me. Thank you for giving me the opportunity to speak to you today. I want to begin by acknowledging the victims and their families. I think about them every day. I pray for their healing, and I know that nothing I say can take away their pain. Larry understands this as well. For many years, he has expressed genuine regrets to his crimes. Larry was a very gifted child. He did very well academically. So well that his first grade teacher had me to come to school so she could talk to me about skipping him from the first grade to the third grade. But I thought about it and everything, and I said no, because I didn't want to push him too quickly, and because I did not know how to properly nurture and support a gifted child. I did the best I could, but I now realize I lack the tools to enrich a child with his position, his possibilities. I began a mother at a very young age. I had my first child at 14, and I did not finish high school at that time. I worked hard to support my children, and by my early 20s, I returned to school to earn my high school diploma. I also completed a 13-month business course at Alexandria Votech. I had one job, and that was at Sears. I worked from 1974 to 2008 and retired from there. Larry's childhood shaped by frequent changes in our home. Although I was on my own, when Larry was born, his father moved in with us when Larry was around 11 months old. Larry's father physically abused me. And when Larry and us tried to intervene, they were also abused. Larry saw things no child should see and experienced things no child should have experienced. When Larry was 4 or 5 years old, his 4 other siblings, my children from my previous marriage, moved to Arizona to live with their father. Larry went from growing up in a full big household to being the only child at home. I believe that sudden loss of his siblings affected him deeply. When Larry was 7, his father and I separated, and he rarely saw his father, sometimes only once every few months. Less than a year later, in July of 1981, I suffered a brain aneurysm. My recovery lasted nearly 2 years. During that time, and he had to grow up far too fast. He became my caregiver within, without going outside like a normal 7 or 8 year old, playing and having a good time. He was there with me. He went to school and he came home, and that's where he was. There were times when I was unresponsive, and that's because when I had the aneurysm, it affected my memory. And Larry, when he would talk to me and I didn't talk right or whatever, he would call his grandmother, which was my mother, and tell her what was going on. In 1985, when Larry was in middle school, he and I moved from Alexandria to Pineville to live with my husband, Nathan, and his 2 sons. That move meant a new school, a new home, and another period of adjustment. When Larry turned 50, his father became somewhat more involved, and Larry began spending some time and weekends at his house. But his father often left him alone with little supervision. For the whole weekend, his dad's gone and he's dead. By the time Larry was 16, I saw changes in him. He withdrew from family activities and began spending most of his time with friends. I regret deeply that I did not ask more questions or look more closely at what Larry was struggling with. I have carried that regret for many years and have asked God to forgive me for anything I failed to see that might have helped him. In the 33 years that Larry has been incarcerated, I have witnessed a true transformation. Larry is not the young man who entered prison. He is thoughtful, patient, and responsible. He has devoted himself to serving others, working as an academic tutor, a mentor, and a hospice writer. He has grown spiritually, completing religious classes in both the Christian and Islamic community. And I want to say this, when a few years after he had been incarcerated, he used to call and I would talk about things that happened, in the Bible and everything. So what he did is he went to a Bible school, Bible college, and he learned. And then when he called me and him to talk the Bible together, I told him a story. One day he wasn't, I could tell that he was kind of down. And I said, I want to tell you a story from the Bible. And I say, it's about a man named Saul. I say, Saul did everything that he could that was evil. He did all kind of things. And one day he was on his way to Damascus. And on his way to Damascus, God knocked him off of that horse or donkey or whatever else he was on. And when he hit the ground, he became blind. He was blind for 3 days. And when God called him, God called him. And he said, Father, here am I. What would you have me do? And I told Larry, God forgave him. His name went from Saul to Paul. And he became one of Jesus' closest disciples. So, look, we've all done wrong. I know I have. But we got to trust and believe in God. And God gave us a second chance. He sent his son Jesus. So I'm asking that too for Larry, because I wish I could explain how I feel about how he has matured being incarcerated. He has matured. He thinks about other people. and everything. Self comes last. After he completed his religious courses and everything, my husband Nathan and I have stood by him all of these years. We speak with him regularly, and every other month we visit him. Initially, Larry Wills initially lived with the Parole Project in Baton Rouge. Nathan and I live about an hour and a half, and we plan to visit him also. My husband's brother, James Spears, lives in Baton Rouge, and he'll be there for Larry too. I believe my son's growth. I believe he has matured, taken responsibility for his crimes, and developed the insight and discipline needed to be a peaceful and productive life in the community. I ask that you give Larry the opportunity to prove outside of prison that he is the righteous and God-fearing man he has worked so hard to become. And once again, I want to thank you for your time and your consideration.
All right, thank you very much for your input. We appreciate that. I need to ask the attorney, Ms. Crouch, who do you want to speak next? You get two more. They had three on the list, and we can't go to 4. I mean, I already let her have almost 3/4 of the whole time. Got between Carrie Myers and Tanisha Smith and Cindy Bright. So one of those needs to be eliminated as a speaker.
Mr. Barros, Carrie Myers, we would like for him to speak, and Cindy.
And who?
Cindy Bright.
Okay, thank you. All right, we'll hear from Carrie Myers next.
Good morning, Carrie Myers with Louisiana Parole Project. We're here to let the board know we've accepted Larry McClinton as a client in our program. As the board is aware, Parole Project 10 years ago was created to assist juvenile lifers who are now made parole eligible by the Miller-Montgomery decision in Act 277 of the Louisiana legislature. Since that time, more than 100 juvenile lifers have been released successfully, living their lives post-release, and Parole Project is happy to have been a part of many of those successes. The 17-year-old Larry that committed these crimes, you heard about his background. That's where we begin. But where we are now is the fact that Larry, over the last 30 years, look at his record, you can look at his programs, you can look at his education, you can look at his community service, the work that he does to give back to his community. You can look at so many of the things that differentiate the juvenile who committed the crimes from the man he is today. When the U.S. Supreme Court made that decision and the legislature's Act 277, we believe that Larry is ready to be released on parole. Him all the resources that Parole Project has to offer in his transition. We're prepared to keep Larry in our program, in our housing, as long as he needs it, and would then transition at the point that both Larry and Parole Project mutually agree that he's ready to move forward, unless this board designates something different. At this point, I think Larry has accomplished everything he can accomplish in prison, from his own personal growth and programming to particularly the things like being a tutor for the last 9 years, steady, consistent, mature, leading RDAP, the RDAP drug program, hospice volunteer, giving back to his community. Those are the things that show the difference between the juvenile and the adult, and the capacity for change. And Larry has demonstrated that capacity. And while Parole Project is willing to provide the services, it's Larry who's done the work to get here. So we just asked the board to consider those factors today and grant his parole.
Thank you very much. Next, we're going to move on to Miss Cindy Bright. That's the person that the attorney would like to hear from, and we're going to hear from her, and we're going to move Miss Tasha Smith to in support but not speaking column. So, Ms. Bright, would you go ahead and tell us what you have to say?
Good morning, and thank you to the board for allowing me to speak today on behalf of Larry. I won't get into all of the successes that he has had up to this point and the time of reflection for the last 30 years. I think his mom and the person who spoke before me was able to give you all of that information. I can speak to you. First of all, my name is Cindy Bright. I am Larry's sister. We share the same father. I am his older sister. And I just want to speak about quickly just the childhood that he grew up in. We lived in a very depressed area. And I feel like our interactions together, Larry and I, he's very smart. He's always been smart. We always talked about going to college together, all of those good things. But the stability and the boundaries is something that he lacked in his childhood, from what I could see. Because I did get a chance to spend time with him through our father. And I will tell you that our father wasn't the best. I don't like saying that, but it's the truth. It's three of us altogether, three siblings, and our father has not been a consistent person in any of our lives. And it has been very difficult. I am very fortunate that I did have a parent that pushed me greatly to do certain things and was very determined. However, Larry did not always have the stability that he needed, and his mother has admitted that. Some of the people that we grew up with were into a lot of unsavory activities, and there was not a strong role model for him to find a way to come out of the neighborhood that we come from. I am in no way making an excuse at all, and I do not ever want to minimize the pain of the families that have been affected. But I just want to let the board know that it was very hard. It would have been very hard for Larry to overcome the circumstances that we grew up in. Alexandria and Pineville, where we grew, it's very difficult, and a lot of people did not make it, have not made it. I'm very fortunate that I was able to make it and go on to college, serve in the military honorably. But Larry did not have some of the same advantages that I had. And I just want the board to take those things into consideration. He has succeeded in doing all of these things over the past 30 years, excuse me, because as I've said, he is smart. He always has been smart. And I wish that, some of the decisions made would have been different so that we could have moved on in life together, doing the same things that we talked about that we wanted to do, military and like college. But please consider the words that his mother has said, and I am confirming that also. As a teenager, I think in a better situation, better choices would have been made. But as everyone has said, over these past 30 plus years, he has done the work and has been accountable for what he's done. He hasn't run away from it. He's saying what he's done. And I just wish you would take that into consideration today.
Thank you. All right, that ends the people who have speaking on his behalf, but I do note that we have several letters in the file, of people who have sent letters on his behalf also. Moving on to who we have in opposition, our first person is going to be the Rapides District Attorney's Office, Mr. Philip Terrell.
Good morning, members of the board. First, let me say that, as you can tell from the record, every member of law enforcement in Rapides Parish strongly opposes this. I think on 4/22 in 1991, the Pineville Police Department responded to a call of a female laying in the middle of Genie Street, bleeding profusely. Her name was Nidra Harms. Neighbors told the Pineville Police where she lived, and it was apparent to the officers that she was suffering from gunshot wounds, multiple gunshot wounds. The officers fanned out around and with her daughter, and it's important to note that one of the first things that the officer observed, there was a broken window on the back of the mobile home. That'll be very important in a moment in my argument. When the officers gained entry, they discovered Sarah, who had no pulse. She had been shot 3 times in the torso and once in the back of the head. She was deceased. That's Angela Hargens, the daughter of Nidra Hargens. If you recall, Mr. McClinton was talking to y'all about when he was explaining what happened. He said that he was in a relationship with her and he went to buy drugs from her or alcohol or something like that, and that they got in an argument. Detective Dana Rashell of the Pineville Police Department, who incidentally is now one of my investigators, was the detective back in 1991 who was the lead investigator on this case. Mr. Rashell would have been here personally to testify to let you know exactly what happened. He had a medical condition and was in the hospital and is unable to travel. But I'm gonna refer at this point to his report and his letter to y'all. And I know y'all have read this, and I'll try to be as brief as I possibly can. I just feel like I need to say these things. An autopsy was performed on Miss Angela Harkins. The forensic pathologist report indicated that she was shot 3 times in the body area. The 4th and fatal shot was discharged to the back of her head while she was laying on the floor. The forensic pathologist indicated that Angela would most likely have survived the 3 shots to her body. Later on, so the crime goes unsolved for a year, from April to April. And at that point, Detective Brad Sutton from the Grant Parish Sheriff's Office called the Pineville Police detectives and said, we have information that Mr. McClinton had murdered the second victim, the victim in Grant Parish, Narvell Larson, or I'm sorry, I don't remember her name, but anyway, and had secreted her body and hidden it in a remote area of Grant Parish. She was shot twice in the head right below her temple. And when the Grant Parish Sheriff's Office investigated this, they thought that perhaps they developed Mr. McClinton as a suspect. He was in the Marine Reserve, so they tracked him down to Northwestern. He was driving the vehicle owned by Narvell on Northwestern Police arrested him and put him in the Nash Parish jail. Grant Parish goes against him when they interrogate him. After they Mirandized him, he confessed to killing Miss Narvell. And he also, they had information that he might be a suspect in the Pineville deal, and he confessed to that. So when Detective Rashell went to interview him in Grant Parish, Mirandized him once again, and he admitted to the killing, but he said he did it because that they were in a relationship that her mother didn't know about. At that point, Detective Rashell confronted him with couldn't happen like that, because he said he shot her in the living room and drug her down the hall. Physical evidence showed that she was killed in the hall. And he admitted to Detective Rachel, according to Detective Rachel, and also what's stated in your summary, in the DOC summary of the facts, that he broke in their home, he burglarized their home, he had the weapon, that he was surprised by Angela, and he shot her. That's a different, he told the first story today. So my argument to y'all is look at your records and look at the police reports. And my point is he's still not taking full responsibility for this. So we have, and by the way, the mother, Miss Neve Hardings, when she came home, according to Detective Rachel, what Mr. McClinton told him finally the second time when he was confronted with his statement was inaccurate, that the second Miss Hardings was shot twice in the torso, once in the larynx. And the Natchez Parish, the Grant Parish lady who was murdered, and Miss Angela Hardings, they were murdered right there. Miss Nidra was shot in the larynx, and if you note from about their only surviving relative is a niece of Nidra. She says that before then, that the elder Miss Huggins, she liked to sing and play the piano, and as a result of her injury, she couldn't sing, she could barely talk, she drug her leg, and certainly that while we don't have any evidence that contributed to her early demise, we can be sure and know that it definitely altered her life. If you notice in the letter from Mr. Casey, the lady from St. Bernard Parish, that's the one I'm referring to, is her niece and the first cousin of Angela. She said that the elder lady was afraid the rest of her life, was miserable, and had problems. It's the state's position that what we have here is two cold-blooded murders. And Miller Montgomery requires, and this is clearly a Miller Montgomery case, Miller Montgomery requires that they have a right to a parole. It doesn't mean that it has to be granted. And it's the state's position that it would be unjust at this point. Let me point out a couple more things real briefly. This board granted a continuance from September until now because Mr. McClinton got really good legal advice that he needed to complete more classes. Well, he's been up for parole every time that he's been eligible, and this board has denied it. All of a sudden, in the last 2 months, he's taken some new classes to show y'all that he's doing the right thing. So I'd ask you to consider that even if in the future that it's appropriate, that more time needs to pass. We need to see whether or not those classes have any effect. It's a position of the state that you still have to examine many factors. Public safety seriousness of the offenses, the callousness of the crime, the effect on the victims. I would submit that none of these crimes were the act of an impetuous youth. I would submit to you that what it is the man killer, because this is as heinous a crime as has been committed in Rapids Parish. The community is concerned about his release, and we just think that at this point it's inappropriate. I would point out to y'all that in one of the latest things that I got, the psychological report from Dr. Sue, Austin, PhD, dated 12/3/25. If you look on page 5 of 7, this is what she says, and an examination of Mr. McClinton. He appears to be reluctant to acknowledge personal limitations and will tend to repress or deny distress or internal consequences that might arise from such situations and limitations of antisocial behavior, compulsiveness or rigidity, poor control over anger, inflated self-esteem, low frustration tolerance, and distrust. I could go on, and there's so many things that I want to say. I know that each of the board members have thoroughly digested everything in this packet as I have. But I would submit to you that the story that you got a situation where the story he's telling today is the same one he told the first time. It's not the truth, based on the Powell Police Department police report and the reports from the Grant Parish Sheriff's Office. The state respectfully requests that at this time that this board deny this part. Thank you very much for your time.
I got a question for you.
Yes, sir.
After all of that research and homework you did and talking with Mr. Rochelle, is it your opinion that it was a total stranger event?
I don't know that. I know that they were neighbors. That's my impression.
Okay, thank you.
Sorry.
All right. We also have in opposition from the Rapides Parish District Attorney's Office, Mr. Robert Murphy, who is here at headquarters but not speaking. We also have several letters sent to us in opposition in the file. And we have opposition from the district attorney in both parishes, the sheriff in both parishes, the chief of police of Pineville, and the attorney general's office. This case has been assigned to Ms. Ledoux, so she's going to ask you a few questions and clarifications, and we'll go on with that.
Mr. McClinton, I've thoroughly reviewed the information in the file. My concerns lie specifically, you had 72 write-ups during this period of incarceration.
Yes, ma'am.
Very unusual. Well, it's not unusual for me to see people who come before me with only 7 or 8 in the same period. I know you went in young, and I take that into consideration. But I want to talk about the last write-up you had in 2020, because that's the one that kind of hangs me up a little bit. Do you remember that write-up?
Yes, ma'am.
Tell me about it.
Write-up dated March the 2nd, 2020.
Yeah.
Okay, ma'am, I had been transferred from Louisiana State Penitentiary to David Wade Correctional Facility. I had a write-up for a cell phone. I had a 30D, which is an unprofessional relation, and I had a 30X, maintaining online accounts. And the online accounts maintained were due to the cell phone, like on Google. I went through that period of, being exposed to a cell phone, being exposed to just the technology, the world around us. And, it definitely was against the rules. I broke them. I also had a 30D at that time, and that was for unprofessional relations. And Now, with that particular write-up, you know, when in this position, when people show you favor, you tend to sometimes take it for more than what it is. Somebody can be giving you a helping hand, and you know, to us, it's like, hey man, this person here likes me. I need to try to move forward with this here, and that was on me, man. I wrote some letters. Those letters were discovered, and not only did I get myself in trouble, but I got a staff member in trouble, man. And again, it was all on me.
It just seems that it indicates that even after you had one parole hearing, you had an opportunity to be released, and now you still making a decision that jeopardizes a release, and just disregard for the rules, and you have put yourself in a position of authority within a certain community subgroup there within the prison, and it's not necessarily conducive to leadership qualities.
No, ma'am. I mean, I was still in the growth stage. That showed a lot of immaturity. And I'm glad you mentioned that, because the good turning point was me actually going to David Wade and meeting Warden Goodwin. You know, he's very, very, very good man, but he's a very, very, very stern man. He kind of called you out on everything. So, you know, being exposed to people like that, it just wasn't Warden Goodwin. There was a lot of people on that particular stand. I caught those write-ups, ma'am, after my first parole hearing. And for me, at that time, I had already, you know, been incarcerated for 27 years. And for a person that has a life sentence, well, for me, having a life sentence, I didn't really understand the dynamics of being considered to be free. It was still like, you know, okay, they've given parole eligibility, you know, I probably won't make it. And so I didn't put all my chips into, you know, put my first foot forward, start to being released. Only after I got at David Wade and a lot of guys that were still in Angola started being released, they actually took those opportunities, and I was like, whoa, man, I've taken myself out of the head. I've taken myself out of the position, you know, to better myself, to be free, right? So going to David Wade and actually seeing it from that perspective away from Angola gave me a much better perspective now. And, you know,
that really plays into to the psychological evaluation that I read, and that you have a interpersonal style characterized by a strong need for affiliation and attention. You're attention seeking and dramatic. And so being in an environment where you have people enforcing strict rules, it seems like maybe you kind of internally rebelled against that strictness. Would that be accurate?
You mean like at David Wade? I mean, before, yes, ma'am, before getting there, you know, definitely, I agree 100%. Sometimes you really have to be put all the way in the corner before you can actually see that, hey, I have to change directions. And you know,
yeah, I understand. You answered that well. I don't have any other questions at this time, so.
I have a question.
Yes, sir.
Your plans, if you were released, Mr. Clinton?
I work a lot in education, and I work with the residential drug abuse program. Working through those programs, I've seen a lot of guys come through it that not only need education, but need that, the same thing that I got while I was at David Wade. You know, somebody that cared and somebody that could actually give you from experience a push in the right direction. So working through transition homes and these transition programs, like with Kerry Myers with the parole project, I want to be the person also to help guys upon reentering to take that step in the right direction. And for me, you know, I understand that this also stabilizes for a job. I've been exposed to education here at Hunts. You know, with a life sentence, you are placed on the back burner of education. I come here to Hunts in 2024, and here is a wealth of educational opportunities. And I discovered something about myself, you know, a year and a half ago. You know, I'm kind of good at it. I took NCCR classes with construction education management through fundamentals of crew leadership as well as project supervision. And I've also completed the crafts of safety, becoming a safety technician and a safety supervisor. And I want to, you know, ultimately put myself in a position where I can actually tutor or perhaps instruct those classes in transition, because the state is moving toward allowing ex-offenders to help instruct in that capacity out there in society. And, you know, the work that I do in here, I want to continue it out there. That's what, you know, my career goals are. I want to kind of stay the course and, you know, continue, you know, serving the people. Listen, I've taken from communities. I mean, you have the reports in front of you. I want to give back. I want to, you know, I want to become one of those people that, you know, the parents are still proud of. And, you know, I heard Mom speak, she broke my heart. I still want to make her proud. I still want to be able to contribute to that society and give back, because I've taken so much, not just from the victims, but from the victims' families. Just like the district attorney said, I can't imagine how she felt with her daughter being gone. Those things I do think about, and I use myself as example. When I'm instructing these guys in here, I don't use scenarios. I use myself as an example. As imam of the Islamic community, when I counsel, you know, young guys coming in that's trying to find an identification, I let them know, man, this is not just something that I identify with. This is something that can help change your life. And I want to be part of the life changing, you know, portion to contribute back. If Brandon released here today, my sentence here doesn't end. You know, my sentence actually began, because all these certificates, they really mean nothing. Getting back out there and using the tools learned from them to help guys in similar situations, and that means everything to me.
Answer this to me. You were 17 at the time you committed the crimes?
Yes, sir.
What's going on with you?
Okay.
What was going on at 17? I mean, don't put it on the family and where you came up and all that.
Just a lot of my life was really fashioned off what I saw, right? And of course, everything is on me, right? I had they had other guys in similar situations that, you know, went on to become doctors and lawyers, right? So it was my decisions, you know, to be accepted by grown peers. It was my decision to seek vainglorious positions in you know, in gangs and be known as somebody. All that was my decision, but that's what was going on in my head. I really wanted to be part of something, part of a family, and you know, that required negative behavior. And
Thank you.
I did those. I did those.
Thank you.
Thank you, sir.
All right.
I have no further questions. Ms. Cross, would you like to finish it up? You know,
Yes.
anything?
I want to thank the board for gathering here this morning and listening to Larry and his mother and his sister. I also want to thank you for the packet that we submitted. There's just 3 points really that I want to address here. First, the district attorney mentioned that this was continued, claiming that he got some legal advice that he needed more programs or certificates. I don't think that's borne out by the facts. If you look at page 15 of the memo that I submitted, you can see a table of Larry's programs and certificates in chronological order. That list ends with his NCCER credentials that he got in August of 2025. Since then, he has obtained a few more credentials, notably a peer minister certification and a certified mentor certification. But those particular certifications, they were the result of work that he had been putting in for many years. For the peer minister certification, he had to take a counseling class and a behavior management class at New Orleans Baptist Theological Seminary. Those classes were done in 2004 and 2014. The third component of that, I believe, is a moral compass class, which he did complete more recently. And then I believe he also did get some hospice certifications more recently. But again, that builds on work that Larry has been doing throughout his incarceration. He started doing hospice volunteer work when he was in Angola. And this also ties into his role as the imam of the Muslim community. He's been doing the work. I can say that I was hired just a little over a month ago, and the primary purpose that I felt like I was hired for was to do some additional investigation as to Larry's childhood and to speak with all of his family members and really get a full picture of what his childhood was like. Because as you know, the district attorney and Mr. Myers have mentioned, he's in a relatively unique situation in that the Supreme Court has said through Miller and Montgomery that juveniles are constitutionally different. Because of their lack of brain development, they have a greater potential for rehabilitation and for reform. And so as a result of that, the board has propagated guidelines to consider the Miller factors. And I just want to highlight on a few of those. So one of those factors is remorse, growth, and increased maturity. Larry has, you can see that he's grown. You can see that in the change in his disciplinary conduct. He's talked about David Wade being a major turning point in his journey and the influence that Warden Goodwin had on him. And most significantly, I would direct you to just look at all the letters of support that were submitted by a diverse cross-section of this community. We have, letters from 2 Baptist pastors. There's a letter from the vice president of the Muslim Reentry Initiative, who specifically spoke about Larry's work in supporting the religion and spiritual development of the Muslim community. We also have a letter from Harold Boudreaux, a family friend and a retired major from the Department of Corrections. And then his sister, Naisha Veal, who is the CFO of NOLA Public Schools. All those people speak to the fact that over the years, Larry has grown and matured. And not only has he grown and matured, but they give examples of how he's grown and matured, and his ability to be vulnerable, and his ability to embrace concepts like healing.
So I think that we should really trust these community members that have put their faith in Larry and can speak to his growth and remorse. The other factor I'd like to point out is the contributions to welfare of others through service. Larry has demonstrated his commitment to service in everything that he does. He has three primary areas that he focuses on: his religious work and spiritual development, his tutoring, and his role as the assistant coordinator of the transition program. That last role, the coordinator of the transition program, that also plays into another significant factor here, which is efforts to overcome substance abuse, addiction, and trauma. You heard about some of that. One thing that I think Larry did not mention was that when he killed Angela Harden and almost killed her mother, he was under the influence of cocaine and alcohol. And when he killed Larvell Green, he was under the influence of alcohol. He has addressed that. He has taken many substance abuse treatment courses. He, starting with the treatment program at Angola, he's taken part 1 and part 2 of Living in Balance. He's taken risk management, mind-altering substances, and most recently, he took a 32-session course on addiction recovery and relapse prevention. So I strongly believe that he has done the work and that he should be evaluated for what he has done. Lastly, I would just remind the board that while law enforcement opposition is something that is certainly to be considered, the law also requires considering the Miller factors, and Louisiana Revised Statute 15574.4 also has conditions that are to be reviewed and minimum criteria. He meets the minimum criteria. Moreover, I mean, and one thing that's interesting too is, since he first went up for parole in 2019, the law has changed and has made it more difficult for one to be paroled. You now have to have a unanimous vote. The period for which the offender cannot have any write-ups has changed from 12 months to 36 months. He's met that. He's almost 5 years without a write-up. Also, I just want to remind the board of a comment that Warden Goodwin made at his 2023 parole hearing. He said, "I can't say anything negative about him. I have a lot of confidence in this individual. I think he is a good candidate despite his conduct record. He's very mature and ready to proceed with life." So, I understand the board's concerns, but I would just ask that you give consideration today, the letters of support and Larry's words. Thank you.
Thank you. All right, that brings us to the point of the vote. Ms. Ledoux, you're first.
The primary factor that any member of this board would consider is that of public safety. I've listened to everything in totality. My vote today is to deny based on psychological evaluation. The type of institutional report in 2020 concerns me because of the mindset portrayed during that. So, of course, with some victim and law enforcement opposition, which is something legitimate to take into consideration. My vote today is to deny.
Mr. Tillett?
Mr. McClendon, 17-year-olds and younger do some stupid things. And I'm glad that the higher courts understand that. It's my opinion that you've shown remorse, growth, maturity, and I hope that you continue to better yourself. My vote today is going to be to grant.
All right. And my vote is also to deny due to the opposition by law enforcement and the multiple murders and attempted murder, more than one person. So today, Mr. McClinton, your parole has been denied, and this concludes our business with Mr. McClinton.
I'm very confused by that whole thing. I don't know what you guys think, but the fact that they let that run on for an hour just to then turn around and deny seems weird to me. Because there wasn't like a whole lot of allocution on their part either at the end, was there? It was just the one's like, yeah, I'll grant, and the other's like, no, we're going to deny, and then that was that. Really odd. Not how I would have expected that to go based on how long they let everybody speak. Because normally they'll cut it short if they're that adamant about things. But I don't know, maybe they weren't that adamant and just not feeling overly verbal at the end. I don't know. All right, well, I hope you guys had fun. We'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar, and then back tomorrow morning, 10 a.m. Eastern, 7 a.m. Pacific for this show. Go have yourselves a great Thursday. I look forward to seeing you all tonight and hopefully tomorrow. Take care. God bless.